one by Professor Clara on her ongoing research that she's currently conducting, and then Dr. Japheth on implementing resolutions of the African Commission. And then in the afternoon, we went into discussions on exploring the role of other actors, and we began with the role of the Peace and Security Council as potential implementation agent, and how that particular AU organ can be utilized for implementation of decisions of the African Commission. Then we had Prof. Rachel Murray, who spoke to us about national mechanisms for reporting and follow-up, and the kind of role that they may be able to play in the implementation of decisions of the Commission and other regional human rights bodies. Then we had Mr. Neil Perma, who introduced us to the kind of diplomatic avenues that are available and that may be used towards the implementation of specifically the rights of persons with disabilities. Before we went for lunch, and then after lunch, we had 2 more sessions. The first one also introducing us to the role of national actors, and we had discussions ranging from the role of national human rights institutions, civil society. We were introduced also to the role of the judiciary in Kenya in the implementation of decisions of the Commission. And then we had our brother Pacharo, who introduced us to task forces and focal points, and how sometimes the eagerness to implement also depends on the kind of philosophy of the personalities that occupy the technical positions within various government departments that are responsible for implementation at the time. And in all of these discussions, we had responses from the African Commission Secretariats, from the Acting Secretary, from other legal officers from the Commission. And then finally, in the evening, we had our last session, which was also country case studies, first by Mr. Sidney Tambasi, who introduced us to a historical legal approach to decision making, and how perhaps if in some instances the Commission had taken a historical approach, there might have been a better understanding of what is the context of the conflict or disagreement, and how to be able to better provide reparations or remedies that respond, having in mind the kind of historical context that have brought that particular conflict to that point. And then we had Dr. Esther Gumbo, who introduced us also to how the decisions, but also soft law of the Commission has influenced judicial actors in Malawi, especially in the decriminalization of petty offenses, and how the Commission's jurisprudence in various forms have been utilized by the courts towards decriminalizing petty offenses in Malawi. This morning, distinguished colleagues, we have a final panel on country analysis and implementation of the decisions of the African Commission, and our chair is Prof. Clara, who will be helping us navigate between the discussions of Mr. Petros, analyzing the implementation of the African Commission's pertaining to Namibia. As I had indicated earlier, we were supposed to have another presentation by Dr. Anthony Munene on the Endorois case relating to Kenya, but unfortunately he's unable to join us this morning. So that we would have another presentation by Dr. Debioti Gosh. I hope I pronounced your name right. Yes, and Dr. Shliao Arahu, who will be talking to us about LGBT-phobic violence and its normalization, and how we can implement the decisions of the African Commission relating to non-violence against persons of gay, lesbian, bisexual, or other sexual minority identities. So without taking much time, colleagues, we're already a few minutes running against time. Just to say that we have reworked the time a little bit, taking into account that we have 2 presentations instead of 3, so that we might the session might finish a little bit earlier than I've actually anticipated. So, Prof. Clara, I will hand over to you.
Thank you very much. So good morning for those who are joining us online from Europe, the Americas, and other countries beyond South Africa. And of course, good morning for all of you who are joining us physically. I would like to welcome all of you to the first panel of our last day of this conference, entitled Implementation and Domestic Impact of the Decisions of the African Commission on Human and People Rights. As you already know, my name is Clara Burbano Herrera, and it's my pleasure to moderate this panel, which is in fact the second session that focuses on country analysis of implementation of decisions of the African Commission on Human and People's Rights. In this panel, we enjoy the presence of two truly experts, namely Mr. Petrus Hatupopi and Dr. Ghosh. Mr. Hatupopi will talk about the implementation of the African Commission decisions with a special focus on Namibia, and Dr. Ghosh will address a highly relevant topic, which is related to the violence that LGBTI people suffer, and he will focus on two decisions of the African Commission. We will also have the pleasure to listen as a respondent to Mr. Pedro Rosa from the African Commission on Human and People Rights. And as it was already mentioned, Dr. Anthony Munemne will not join us today. So that means that we have a little bit more of time. That also means that I will not be super strict with the time, but please don't abuse of my generosity. Without any further remark, I would like to introduce our first panelist. If that is okay with you, I will start with Mr. Petrus Hatupopi. Mr. Hatupopi holds a Bachelor of Laws from the University of Namibia and a Master of Laws from the University of Cape Town. He has worked as a senior legal officer at the High Court of Namibia, also as a legal assistant at the African Commission, and as a legal associate in the Office of the Legal Counsel of the African Union, among others. Mr. Hatupopi, you have the floor. Please do not forget to talk very slowly, because our translators, sometimes it's very difficult for them to follow. Thank you.
Great, thank you. Yeah. So I have identified various forms of interactions and engagements between Namibia and the African Commission, and I've also looked into the various decisions that have been adopted by the Commission in those engagements and interactions, and I've now tried to analyze implementation, where implementation is needed of those various decisions. So just to give you a general intro, layout, and flow of work, Namibia obtained independence on the 21st of March 1990, and then we ratified the African Charter in 1992. That was almost 2 years after independence. It's a good indicator of the commitment of Namibia to promote and protect human rights. So I'll be talking about the decisions emanating from communications in terms of Article 55 of the Charter, decisions emanating from the concluding observations and recommendations on periodic reports submitted by Namibia under Article 62. Oh, sorry. I will be talking about the decisions emanating from the communications submitted in terms of Article 55 of the Charter, and also the decisions emanating from the concluding observations and recommendations on periodic reports submitted under Article 62 of the African Charter, and also the recommendations that are emanating from the promotion mission reports. I'm a fast talker, sorry. So to date, Namibia has been cited as a respondent in two communications. One as a direct respondent, and that's under Article 239, which was a communication instituted by Interrights on behalf of Mr. Sekunda. And in this particular case, Namibia is Namibia as a direct respondent because Namibia is the only respondent in this particular case. And there's also a communication 409, which is the communication of Lake Muyandu, Mbani, and Benjamin John Fripp, represented by Mr. Norman Chombe, and versus Angola and 13 others. And in this communication, Namibia is the 8th respondent. So I would say Namibia is an indirect respondent in this particular communication because Namibia was cited as a respondent by virtue of being a member of SADC. And this is a communication that was challenging the decision of SADC heads of state and of SADC summit of heads of state and government to suspend the work of the SADC tribunal. And I'm sure most of us should be aware of this particular communication or circumstances leading to the closure of the SADC tribunal. So I'll start with the case of Mr. Sekunda. This is a case that alleged violation of the right to liberty as guaranteed by the African Charter. Mr. Sekunda was arrested under suspicions of being a UNITA collaborator or rebel in Namibia. And then he was arrested with no reason. He didn't appear before court. And then he managed to institute proceedings before the High Court to challenge his arrest and detention. And it was found that his arrest and detention was unlawful by the High Court of Namibia, and it was ordered that he must be released and not be deported back to Angola. But the Minister of Home Affairs refused to implement the court order. So Interrights then brought a matter before the commission, but then at the same time, his lawyers in Namibia brought an application for contempt of court before the High Court again. So this particular communication was found inadmissible by the commission because it was still pending before the High Court, and it couldn't proceed to merits. So there's no question of implementation here. That's what happened to this communication. And also maybe to just note that the Minister of Home Affairs was later found to be in contempt of court, which reflects well on the judiciary of the Republic of Namibia. And so there was no need to proceed to merits in this particular communication. And also to note that, what the positive aspect or positive thing that stands out from here, insofar as the relationship of Namibia and the Commission is concerned, there was a letter of appeal that was written by the chairperson of the African Commission to the Minister of Foreign Affairs. The letter was written on the 19th of February 2001, and on the 22nd of February 2001, the Minister of Home Affairs replied to that letter of appeal, which is a good, it's a positive fact to look at the fact that Namibia could respond to that letter within those days. Of course, of countries that receive correspondence from the Commission and they just put it aside, don't respond. But this is a good indicator from Namibia as well. And also, Namibia submitted arguments on admissibility in this particular matter, and that's also it's a good indicator of respect for the mandate of the Commission. And then we have communication 409, which is the one of Lake Muyandu, in which Namibia was the 8th respondent, which has to do with the closure of SADC. And we may all be aware of what happened in Zimbabwe during the land reform process, when through an executive decision, some of the holders of title deeds to agricultural land in Zimbabwe, the land was taken away. And then the SADC heads of state and the SADC summit of heads, and then the summit of heads of state and government of SADC took a decision first to suspend the tribunal, and then later on they decided to completely paralyze the tribunal, and then the decisions of the tribunal could not be implemented. So the applicants in this matter tried out to challenge the suspension of that the suspension and closure of the SADC tribunal. So it was alleged that they are in violation of Article 7 and Article 26 of the of the African Charter. So this particular communication was considered on admissibility, and it went on to merits, but it was found that, you know, there's no violation of Article 7 and Article 26 because they don't guarantee access to international tribunals such as the SADC tribunal, but they only guarantee access and impartiality of national courts. So in this particular communication as well, there's no question of implementation because there's no decision that needs to be implemented. But the only cause for concern in this particular communication is that it's only one respondent state that made submissions on merits, and that was Mauritius, and all other 13 respondent states totally ignored the request from the Commission to make submissions, including Namibia, to make submissions on merits, and that doesn't reflect well on those member states. So there's also no, so those are the only two communications instituted against Namibia, and they all don't require implementation. So I tried to look into why only two communications relating to Namibia since 1992 when we ratified the African Charter. Why only two? I mean, it's not a bad thing, but it could be a bad thing. And so I tried to find out why only two communications. So it could be due to lack of awareness of the Commission's communication procedure against Namibians, or I mean among Namibians, but it doesn't seem to be the case because there are no facts to support that from my analysis. And it could be due to lack of confidence in the communication procedure, but also it doesn't seem to be the case from my analysis as well. It could be due to absence of human rights violations in Namibia. I don't think there are no human rights violations in Namibia. I mean, there's no perfect country. There should be a few human rights violations here and there. So it could also be due to the availability of strong and independent institutions within Namibia to address human rights complaints at the domestic level, which then means that domestic remedies are available and accessible and effective at the domestic level, as required or as per Article 56 of the African Charter. So I think this is the case. This is the case, and I'll continue to explain why. So in the past few years, we have seen the government being sued successfully within the local courts. We have seen cases of medical negligence, cases of forced sterilization, cases of police brutality and torture being brought before the national courts and the victims getting remedy at the domestic level. We have also seen judgments being passed by the High Court and the Supreme Court that promote and protect the rights of LGBT community. And of course, some of these judgments were not received by the members of parliament, legislators, and the politicians as well. Some criticize these judgments, and it shows you how independent the courts are in protection and promotion of human rights, which doesn't really create the need for citizens to continue to the African Commission because they are getting remedies at the local level. So this is what you have seen in the past years. It could be one of the reasons why we have very few communications from Namibia reaching the African Commission. And we also have a relatively clean human rights record. If you look at the reports of various NGOs and various organizations working in the area of human rights, the reports of Amnesty International, Human Rights Watch, and the reports of the U.S. State of Department, we relatively have a clean human rights records. So we don't have really cases of widespread and systematic human rights violations. We have few isolated and sporadic cases within the country, and that's one of the reasons why we have very few communications before the Commission. And there's been also a strong and demonstration of a strong commitment to promote and protect human rights. We have seen it through some of our politicians as well, the work they do and the pronouncement they make as well. And then also one of the factors why we may have very few communications that we didn't have really major changes in government since independence. We have only had 2 presidents so far, and we are likely to have our 4th president, who is a female, next year. And so far, they are all from the same political party. So there's been a bit of continuity, and there hasn't been really, major changes in terms of approach to human rights promotion and protection. And that's one of the reasons why we have very few communications before the Commission. And then I'll move on to the concluding observations and recommendations on state periodic reports. I would like to mention that Namibia is up to date with our reporting obligations under the African Charter, and we have highlighted the importance of reporting as required in terms of Article 62. It helps to monitor the implementations of all the decisions that pertain to that particular country. So Namibia is up to date. And where Namibia was a little bit behind with reporting, Namibia managed to submit combined reports in order to catch up. And I think that's something that other countries should also, emulate and do the same as well in order to keep up with their reporting obligations. So it's a list of the reports that Namibia has submitted so far. And it's very unfortunate that some of these reports are not on the website of the African Commission, so I couldn't find them. Especially, like, for example, the initial report, I could not find it. The second periodic report, I could not find it. And I would just like maybe to request the Commission really to make sure that all the documents pertaining to countries are on the website so that it can be easy for researchers. Let me be able to open a tab of a country, and then I'll get all the documents relating to that particular country on the website of the Commission. So in my paper, I've looked at the concluding observations and recommendations of the 6th periodic report and the 7th periodic report, and I've done a comparison to see how these recommendations were implemented. So I've only looked at the last 2 recent concluding observations in order to analyze the implementation as well. And also, maybe to just note that the Commission has commended Namibia on several occasions in all the 2 concluding observations for well-detailed responses and reporting on the implementation of its concluding observations. So that's one aspect that has come out from this. Means Namibia has been really forthcoming with information, and Namibia has been really ready to respond and update the Commission on various measures taken to implement the concluding observations of the Commission. I'm not going to go into details, but in my paper, I've detailed all the concluding observations, and I've provided all the measures and information relating to the implementation of those concluding observations. Because of time, I'll skip some of the other things.
I can give you 2 minutes.
Okay. So also maybe with regard to the promotion missions, also Namibia has been commended for implementing all the recommendations emanating from promotion missions. To date, the Commission has conducted 5 promotion missions to Namibia. Of course, we know of countries where the Commission has never stepped foot in, but to Namibia, they've been there 5 times, and that's really commendable. And there's been positive feedback coming from the Commission insofar as the implementation of the recommendations emanating from the promotion missions. And it's also an indication of the openness of the government of Namibia to welcome the Commission into the country and for them to see what's happening on the ground. And it shows that there's really nothing to hide on the part of the government. So, and also I would like to just identify the key players in the implementation of decisions that contribute to what I'll call maybe a success story. We have our permanent mission in Addis Ababa and our Minister of International Relations and Cooperation that has been really active and engaging and ensuring that all the correspondence from the Commission reach the headquarters on time. We have a Department of Legal Services and International Cooperation and Ministry of Justice that's responsible for drafting and reporting before the UN and the AU. And they are also responsible for coordinating the implementation of the decisions of the Commission as well. We have the Directorate of Law Reform that leads the implementation of the recommendations relating to law reform. And then we have the Attorney General that leads the process of ratification of international human rights instruments. And maybe to just give an example, one of the concluding observations and recommendation has been a recommendation that Namibia should, amongst others, ratify the protocol on the rights of persons with disabilities. And then I think in April, the Center of Human Rights undertook a promotion mission to Namibia in April this year to advocate for the ratification of the protocol on the rights of persons with disabilities. And then in June this year, Namibia ratified the protocol on the rights of persons with disabilities. That's how fast Namibia has been in the implementation of some recommendations. And then we have the Office of the Attorney General and other line ministers as well. I've mentioned that. and also other ministries, Ministry of Health and Education, play a role in implementation of the decision of the Commission. And maybe to just also point out the areas in which we are slowing down to implement the recommendations of the Commission, issues of land reform. Unfortunately, we have the issue of land and access to land and housing, and part of this we can blame it on our colonial past as well. We are still trying to recover from that, and we are trying to adopt appropriate laws to address some of these issues of access to land and housing as well. Issues of protection of indigenous people's rights. It doesn't mean that the government is not doing anything. The measures that the government is adopting, but we are a bit slow in this. Issues of unemployment, combating domestic violence. We have good laws in place, but the implementation, we are a bit lacking there. And also the issues of budget allocation to the sector of health and education. We are also a bit, I mean, there's been an increase in the allocation of budget to health and education, but sometimes the issue is the execution of budget, where the ministries are not really doing well in that. And that's what we are picking up from the recommendation of the Commission as well. So, and also the issues of human rights violation by the police, brutality and torture as well. We have good laws in place, but we are still getting cases of that kind of nature. And that's why I've said earlier that there have been cases of of the state being successfully sued in the High Court as well. And then also the improvement of areas of detention and correctional facilities as well. We are a bit slow in the implementation of those recommendations.
You have 30 seconds.
Thank you very much. So I've come to the conclusion. So relatively, we have a good human rights record, and we have done a little bit well in the implementation of the recommendation of the Commission. And there's, I mean, what I'm seeing from Namibia is it's political commitment and political will to implement the recommendations of the Commission as well. So far, we have good relations, and we have been doing well with the Commission. And yeah, I've listed the detailed conclusions here. I'm not going to go deeper into that. Thank you very much.
Thank you very much, Mr. Hatupopi, for this very enriching and interesting presentation. And I must admit that I come from Latin America, and for me, it's not very common to hear what he just said, that Namibia only has 2 communications before the African human rights system for 3 reasons. The first one is because in Namibia, it's very exceptional that human rights violations occurred. Secondly, when those violations occurred at the national level, the state authorities bring justice to the victims. And the third one is because there is a political will to protect and guarantee human rights. So that's very exceptional, and we will see how our respondent will say about that. Thank you very much, and now we will follow, we continue with our second panelist. Dr. Ghosh is a human rights lawyer. He's originally from India. He holds a PhD from the Central European University. His PhD focused on transgender rights in India, Brazil, and South Africa, and he's currently a postdoctoral researcher at the University of Pretoria. The title of his presentation is Against LGBTI-Phobic Violence and Normalization, Implementing 2 Decisions of the African Commission. Dr. Ghosh, please proceed.
Good morning, everyone. Hello, ladies, gentlemen, and friends beyond the binary. I'm Dr. Debjyoti Ghosh, and on behalf of my co-author, Dr. Araujo, thank you. I would like to thank the organizers for this opportunity to present our findings to the African Commission. So by many accounts, the African Commission has been silent and somewhat evasive on the matter of sexual orientation and gender identity. The exceptions to this trend are the landmark resolutions 275 of 2014, which assures citizens protection against violence and other rights violations on the basis of their real or presumed sexual orientation and gender identity, and Resolution 552 of 2023, which promotes and protects the rights of intersex persons in Africa. This paper will explore the implications of these resolutions for LGBTQI+ activism and for the work of LGBTQI+ organizations working for rights, safety, and legal recognition in Southern Africa. In particular, it will assess and evaluate the manners in which various actors, organizations and stakeholders are engaged in implementing the resolutions. We intend to make an intervention grounded in legal analysis and reasoning, but also in a case study at the ground level. This is important considering that the question of LGBTQI rights in the work of the African Commission and the African Union has been relatively marginalized in the scholarship on queer struggles and activism in the continent. While some excellent articles have already been published in recent years, we still need further studies that not only look at African legal frameworks from a comparative perspective, but also social legal approaches that are attuned to the specificities and complexities of local realities, from lawmaking to the complicated issue of implementation. So drawing on these premises, the paper is divided in 3 parts. In the first moment, we present a critical analysis of the resolutions in terms of their content, as well as the rights and protections they set in place. We will be interested in exploring the legal definitions of harm, violence, and normalization practices as presented in these texts. We will argue that these 2 resolutions can be interpreted as providing a progressive and expansive language with which to oppose often violent and harmful normalization practices targeting LGBTQI+ persons. In the second half of the paper, we will look at one case study where actors and stakeholders have demonstrated interest. Do I need to slow down? I'm fine. Okay. Demonstrated interest in engaging the decisions in an inclusive manner, pursuing their implementation. In particular, we will look at, no worries. Oh, okay. I hope I get some extra minutes for this.
I already said, don't abuse of my generosity, but you will have.
So in particular, we will look at the Angolan Identity Archive, AIA, and LBQ Collective based in Luanda. AIA has been active in law-based activism and advocacy, especially considering the recent decriminalization of sexuality in the Angolan legal landscape in 2019. More recently, in 2023, they filed an anti-discrimination case, hoping to create a precedent and a more robust system of protection for LGBTQI+ people in Angola. In exploring this case, we hope to shed light on how the resolutions may work on a transnational and local level alike, eliciting the engagement of different actors and collectives in their implementation. Despite more and more African countries decriminalizing same-sex sexual acts and accepting in different ways non-normative gender identities, progress is slow. Violence against queer people in Africa on the basis of their sexual orientation and gender identity is a ground reality. Yet, all 54 countries are parties to the African Charter on Human and People's Rights, which prohibits discrimination and guarantees equal protection under law. However, when it comes to protecting all members of the population without discrimination, several states fall short, and indeed some of them have actively campaigned against LGBTQI+ rights. One could argue that the ambivalent attitude of the African Commission on Queer Matters is partially to blame for this. As it hardly needs saying, the African Charter guarantees the principles of non-discrimination and equality before the law, the rights to life, dignity, and physical integrity, the guarantee against cruel, degrading, or inhuman treatment or punishment, and the right to a fair hearing before competent national courts. In addition to these protections, the protocol of the African Charter on the Rights of Women, known as the Maputo Protocol, requires state parties to take specific measures to combat violence against women, regardless of their sexual orientation or gender identity. As a means of interpreting the rights in the Charter, the African Commission on Human and People's Rights have passed 2 hugely progressive resolutions, as mentioned earlier. So the resolution 275 or 2014, which is known as the Resolution on Protection Against Violence and Other Human Rights Violations Against Persons on the Basis of their Real or Imputed Sexual Orientation or Gender Identity, derives its basis primarily from Article 2 of the African Charter that prohibits discrimination on the basis of any distinction. It also invokes the Equal Protection Clause, which is Article 3, and inviolability of everyone's life and person's integrity, as well as freedom from torture, Articles 4 and 5. Resolution 275 of 2014 came about as a reaction to the heightening violence against queer people in different countries. The violence included assault, rape, murder. The resolution, while voicing the concerns of the African Commission about such activities, called upon states to take action against such violence, whether by state actors or non-state actors. It also stressed on the necessity for protecting human rights defenders who are working on the rights of sexual and gender minorities. Thus, per the rights in the African Charter, the basic principles of do no harm and non-discrimination ought to be enough to oblige the states to look after their queer citizens, as well as ensure that state actors do not indulge in discriminatory behavior. However, the violence continues unabated, and despite this resolution, the African Commission categorically refused to grant observer status to 3 human rights organizations, namely Alternative Côte d'Ivoire, Human Rights First Rwanda, and Synergia, Initiatives for Human Rights, stating in their rejection that sexual orientation is not an expressly recognized right of freedom under the African Charter and is contrary to the virtues of African values. This decision was passed down in the final communique of the 73rd Ordinary Session of the African Commission in the Gambia in November 2022. This wasn't the first such action, however. In 2018, the African Commission stripped the Coalition of African Lesbians of their observer status, working on an ask by the Executive Council of the African Union to decide on observer status based on fundamental African values, identity, and good traditions. In a few months after this, Resolution 552 of 2023, which is the resolution on the promotion and protection of the rights of intersex persons in Africa, was passed. This also derives its basis from Article 2 of the Charter and further buttresses its resolution with Article 16, which guarantees the right to the highest attainable standard of physical and mental health. It also invokes Article 5 and Article 9, which gives the right to access to information, which includes medical records and histories. The resolution also considers Article 5 of the Maputo Protocol and Article 21 of the African Charter on the Rights and Welfare of the Child, both of which prohibit harmful social and cultural practices. Now, the Resolution 552 is quite expansive in what it expects the parties to enact for protecting and including the intersex population within the mainstream. It recognizes the fact that most state parties do not have any legislations or policies around intersex people. Apologies for that. Around intersex people, and the parties need to legislate. Amongst other clauses, the resolution urges state parties to stop non-consensual genital normalization procedure and to ensure the respect for their right to physical integrity, autonomy, and self-determination. It urges the state parties to end discrimination against intersex people based on their traits and characteristics and initiate anti-discrimination measures, raise awareness among all branches of government. Indeed, the problematics of infanticide, abandonment, and non-consensual medical procedures carried out to quote-unquote normalize as well as sterilize cannot be emphasized enough. However, what is interesting in this matter is that being intersex, while often clumped together with queer, gender, and sexual identities, is treated separately and seen as wholly a different issue. In fact, the resolution refers to being intersex as a handicap. Now, as a framework, this may actually be detrimental to establishing rights for intersex people and can be used to justify non-consensual invasive medical procedures by state and non-state actors. Thus, on the one hand, the reasoning given for the African Commission's rejection are the 3 aforementioned human rights organizations as observers in 2022 shows how the institution was backtracking on the 2014 resolution. On the other, the same commission has produced a long, robust list of state obligations towards intersex people in the 2023 resolution. Thus, a challenge to African LGBTQI+ human rights defenders is how to navigate these seemingly conflicting positions to be able to engage the Commission's decisions in the most progressive, inclusive, and effective manner. Indeed, the Commission talking of the virtues of African values, while taken from the African Charter, Article 29, Part 7, seems to overlook the fact that Article 29(7) speaks of promoting positive cultural African values. Such positive African values cannot be the basis of prohibiting equal rights to the African LGBTQI+ populace. Also, to say that African cultural values do not encompass LGBTQI+ rights goes against the protection mechanisms that various African countries have already put in place. Thus, to not allow LGBTQI+ rights defenders organizations as observers sends out the message that the rights of LGBTQI+ people are not within the ambit of human rights as enshrined in the African Charter. Also, while in both resolutions the clauses include protections for human rights defenders' works, evidently the same cannot be said about the actions of the African Commission. By not allowing observers from such organizations, it is sending out a dangerous message that the rights defenders are outside the ambit of protection required to function. Now, while the African Commission's reasoning to not grant LGBTQI+ NGOs from observer status is extremely flimsy, it cannot deny the spirit of anti-discrimination that is laid out in the African Charter, Article 2, Equality before the law, Article 3, nor the right to inherent dignity, Article 5. The resolution 552 echoes these principles and much more. The decision is of particular significance to LGBTQI+ rights in the continent because of its unprecedented position against non-consensual genital normalization procedures. While the decision is apparently restricted to a particular group within the LGBTQI+ acronym, one could argue that its vocal affirmation of physical autonomy and self-determination regarding sexual characteristics could potentially have positive repercussions on legal struggles around sexual orientation and gender identity as well. Especially considering that intersex rights, activism, and advocacy in the continent have been developed alongside SOGI agendas, Resolution 552 may have a spillover effect insofar as it opens a framework from which to think about broader issues of bodily integrity, physical autonomy, and self-determination for a minority group, while also repudiating stigmatization, retaliation, or criminal prosecution based on sexual characteristics. So an important question that arises here is if this resolution may be amenable to an extensive legal interpretation, whereby its protections of intersex rights may work as a gateway to articulate and demand rights and protection relating to sexual orientation and gender identity. In order to better understand such extensive interpretation, one might look at similar rights granting decisions and legislations from within the global South itself. For instance, that of Brazil, where the Supreme Federal Court has often been the flag bearer of LGBTQI rights. And in fact, even when the parliament has been silent, it has decided cases on LGBTQI rights protections on the basis of race-based discrimination. And as recently as August 2023, racial slurs have been equated with any sort of homophobic or transphobic slurs, and thus giving them the equivalent punishment for them. The Brazilian case shows that through public interest litigation, a given legal framework can be interpreted in an extensive manner to produce change that is not necessarily requiring action from parliament or legislators, and without the creation of a new set of laws. Moreover, it does not require to be explicitly quoted in the legislation for extensive interpretation. To be sure, for this type of extensive interpretation to occur, a set of circumstances must be in place, such as the presence of a strong civil society that can apply pressure on the judiciary, the availability of evidence or data that supports an extensive understanding on the subject matter, and so on. While the Resolution 552 could potentially be amenable to an extensive interpretation to also refer to the bodily integrity, physical autonomy, and self-determination of other groups within the LGBTQI+ acronym, the question will become whether courts will be receptive to such an extensive reading. In the case of Brazil, there was an eagerness exhibited by the judiciary and indeed an overall level of judicial activism as well. The challenge to LGBTQI+ movements in the continent, hence, will be how to devise or push for new and more inclusive strategies of implementation and adjudication, whereby existing...
I will ask you please to talk a little bit slower, and you have still 3 minutes, okay? 3 minutes.
Apologies to the interpreters. The challenge to LGBTQI plus movements in the continent. Hence will be how to devise or push for new and more inclusive strategies of implementation and adjudication, whereby existing legal frameworks are taken seriously, but also potentially interpreted in more transformative and extensive manners. So we come to Angola, where, as elsewhere in the global south, public debate and state policy around issues of sexuality have been largely shaped by the HIV/AIDS global health agenda. And the sources of funding that have been presented to the state have, both state and non-state actors, have been about working on health grounds. At any rate, the attention and resources invested on HIV-related public health interventions opened new opportunities for queer political organizing and institutionalization. This particular quote is from Pamina Sebastian, one of the activists involved in the RIS Angola project, where they said the context of opportunity for the creation of LGBTQI movement in Luanda has a history that I think is a bit similar to many regional collectives, which is a history influenced by projects related to HIV. Before that, there were gay people already, there were gay parties and all of that. The USAID project, which particularly was related to the funding, related to key populations, came to lead all of this in the direction of a different organizing culture. Now, Pamina is alluding to the process of NGOization of LGBTQI plus activism prompted by HIV/AIDS related funding and political priorities over the last few years, especially relating to demands for the professionalization of activists, the institutionalization of activists, mobilization around particular organizations, and the bureaucratization of community-focused initiatives and the methods of intervention. While this in turn, while this turn to the NGO structure raises relevant questions that are yet to be further studied, it has also presented fantastic opportunities to study the LGBTQI plus visibility and empowerment in Angola, including by enhancing the ability of the queer movement to enter in dialogue with the state and other actors. As Carlos Fernandez, one of the founders of IRIS Angola, stated, through the issue of public health, you get to meet many public actors in the same space. So you can get all of them to start talking about this. Besides this conversation, this was also a way where we started a dialogue with the state, but not in a public manner. While HIV/AIDS has been a central concern in queer activism and probably one of the most important sources of funding to organizations and activists alike, over the years, important training and sensitization activities have been carried out on the problems of stigma and discrimination within health units and with the Luanda police. In 2019, in 2019, the reform of the Penal Code, which repealed the colonial era article criminalizing vices against nature, brought about new possibilities for placing rights and discrimination at the forefront of queer activism, especially because it included sexual orientation in its anti-discrimination provision alongside race, color, ethnicity, place of birth, sex, disease or physical disability, belief or religion, political or ideological convictions, or social origin. In its Article 214, the new Penal Code outlaws discrimination based on these parameters in terms of employment, refusal of goods, including in public service, impediments to one's economic activities, or as grounds for penalizing or firing an employee. While news of Angola's criminal reform traveled the world with Western observers mostly celebrating decriminalization as another victory against quote-unquote African homophobia, which is an idea generally presented in rather stereotypical and simplistic manners, from the point of view of Luanda, the picture was rather different. Many activists described the legal changes introduced as underwhelming, if not problematic. In part, this critical reception still slower. How much time do I have? So this particular penal code was seen as an attempt to pinkwash, and that a lot of civil society organizations and NGOs are looking for test cases. And in fact, in 2019, they did 2023 July, AIA and a team of lawyers filed a test case on behalf of a victim where criminal charges were leveled against the accused. And as you can see, Article 171 defines the crime of threat, where a party threatens the physical integrity of another by whatever means. Article 214 defines the crime of defamation where a party expresses or communicates with the intent of offending the honor of another. This article determines a higher penalty if the act of defamation is informed by discrimination based on a list of several factors, including sexual orientation. Article 380 defines the crime of inciting discrimination where a party, by whatever public means, incites hate against another. The article mentions sexual orientation as one of the several categories protected by it. Now, I've come to the conclusion. I will not be going further into the details of the case at this moment. This paper has been an exploratory attempt to map the inclusive potential of 2 resolutions of the African Commission for LGBTQI+ rights in the continent. We have argued that in spite of the patent progress in terms of queer rights that is encapsulated by resolutions 275 and 552, the Commission's lack of more sustained support to SOGI-esque rights may pose a challenge in implementation, as there seems to be a lack of political will in enforcing the resolutions. We have suggested that litigation may be a way in which the transformative potential of both the resolutions can be activated in terms of legal reasoning and judicial action through extensive interpretation and judicial activism, but also through public interest litigation brought about by queer movements, as is currently happening in Angola. Now, that brings me to my final remark. I would urge the African Commission to look at queer movements as equal movements when it comes to minority rights instead of marginalizing them and putting them on the sidelines, primarily because we are not in a world where all animals are equal. Some animals are more equal than others. We should all be equal on this platform. Thank you so much.
Thank you very much, Ghosh, for this very interesting and clear presentation regarding the work of the African Commission on Human and People Rights in the ambit of LGBTI people. I think that you say that is a great progress, but still there is a little bit of lack of political will in enforcing these resolutions. Now we have concluded presentations, and we will move to the respondent, Mr. Pedro Rosa, from the African Commission on Human and People Rights. So you have the floor to reflect on some of the issues raised by the panelists. And if that is okay with you, I will give you 15 minutes. You have the floor.
Merci beaucoup, Madame la modératrice. Bonjour, collègues. Je voulais signaler à Madame la modératrice que le président de la commission voulait parler d'abord avant que je réponde. Merci.
Je salue tous les conférenciers ce matin. Salue également Madame la modératrice pour la manière avec laquelle elle conduit nos débats ce matin. Je tenais à vous féliciter pour le respect, la rigueur, pour le temps. Féliciter aussi nos deux brillants juristes qui nous ont entretenus ce matin. J'interviens simplement compte tenu de la sensibilité de la question liée à la protection des personnes LGBTQI+. Je n'ai pas le pouvoir, dans ce cadre-ci, de devoir modifier l'agenda. Mais si vous autorisez, je suis en train de demander votre autorisation. Mon collègue Pedro, qui avait déjà été programmé, il pourrait apporter les réponses. Mais si vous avez un peu de temps, à la fin, quand il aura fini, pour ne pas perturber le programme tel qu'il est là, si je peux obtenir la parole pour refixer un certain nombre de cadres, de questions, parce que c'est une question institutionnelle, c'est une question extrêmement importante pour l'Afrique entière, pour tous les pays d'Afrique. C'est la raison pour laquelle je voudrais formuler une philosophie générale de la Commission africaine des droits de l'homme et des peuples sur ces questions, parce que quoi que nous fassions, on n'arrêtera pas de nous critiquer sur ces questions-là. Je vous remets la parole, si vous pouvez autoriser, quand il terminera, que je fixe aussi le cadre. Merci, madame.
Merci, Monsieur le Président. Tout d'abord, pour féliciter les deux collègues qui ont fait leur brillante présentation, qui ont contribué pour la continuité des réflexions sur les questions qui ont été soulevées et qui vont certainement aussi permettre à la Commission de mieux s'approprier de ces réflexions et les intégrer dans son plan de travail afin d'améliorer le cadre de suivi d'exécution des décisions et de ces décisions. Je vais commencer d'abord par M. Petrus, qui nous a fait part de l'expérience du Malawi dans sa relation avec la Commission, soit au niveau de l'exécution des décisions dans le contexte des communications individuelles, soit au niveau du rapport périodique des recommandations générales finales qui sont sorties après la discussion des rapports périodiques. Dans les deux cas qu'il a présentés, la première communication qui a été déclarée irrecevable, malgré le fait que la communication a été déclarée irrecevable, la Commission avait envoyé une lettre au Malawi manifestant sa préoccupation sur les conséquences possibles de la déportation, Malawi, les conséquences possibles de la déportation de la victime. Namibia, pardon. Et je pense que malgré le fait que la Commission a déclaré la communication irrecevable, en tenant compte qu'il y avait une lettre de concern, cette lettre-là pouvait quand même être utilisée pour faire le plaidoyer auprès de la Namibie dans le sens de éventuellement éviter la déportation de la victime. La deuxième situation, elle est relative à une autre communication dans laquelle la Commission n'a pas constaté la violation, mais l'expérience de cette communication nous montre que la question de l'inexécution des décisions, elle n'est pas seulement, ne touche seulement la Commission. Le problème existe aussi même au niveau national, que les juridictions nationales, dans le cas de Namibie, ont pris des décisions qui n'ont pas été exécutées par le gouvernement. Donc, la difficulté au niveau de l'exécution, elle se trouve au niveau interne, aussi bien qu'au niveau international. Après, il y a la deuxième présentation qui est relative à la question de LGBT. Je pense que le président va donner plus de détails sur ça. Dans ma qualité de responsable de la gestion des communications au niveau de la Commission, je pense que si la difficulté en ce moment, on peut dire que se trouve au niveau du statut d'observateur, c'est toujours possible d'explorer la partie relative aux communications. S'il y a des violations concrètes avec des victimes, c'est toujours possible de saisir la Commission dans le contexte de communication individuelle, article 55 de la charte, et la question sera traitée. Et à ce niveau, je pense que les deux résolutions de la Commission, elles sont toujours importantes dans le contexte de contentieux. La question relative au statut d'observateur, je la réserve au président de la Commission. Merci beaucoup.
Thank you very much, Mr. Pedro Rosa, for that reflection. So now I give the floor to Honorable Chairperson. You have the floor now.
Merci beaucoup, Madame la modératrice, je voudrais apporter quelques précisions sur la question importante de la protection de la communauté LGBTQI+. Dans les conclusions de Dr. Gauche, il est indiqué qu'il y a un lack of support, un manque de soutien de la Commission à ce qu'on appelle le SOGIEC. On ne peut pas laisser cette expression de cette manière au cours de cette importante conférence, dans la mesure où, vous le savez, d'abord, la Commission a répondu présent à toutes les manifestations des SOGIEC. Et moi-même, lorsque j'étais arrivé comme jeune commissaire, j'ai participé à une de ces rencontres à New York, Washington, je pense, sur ces questions-là. Et depuis lors, nous n'avons jamais décliné une invitation dans le cadre des SOGIEC qu'on avait fait avec les Nations Unies et le Haut Commissariat des Nations Unies aux droits de l'homme. C'est déjà une forme de soutien et nous n'avons jamais dit au cours de ces réunions, nous n'avons jamais donné une position indiquant que on était contre la communauté. Hein. Donc, il faudrait que peut-être dans les jours à venir, dans une autre conférence, vous adaptiez cette partie parce que vous êtes très, très affirmatif, alors que c'est le contraire qui est vrai. Il y a d'abord un soutien par la forme de participation dans le débat, accepter de discuter et de trouver les voies et moyens pour pouvoir aller plus loin. Effectivement, nous avons 2 résolutions à la Commission. Ne prenez pas ça pour quelque chose de très simpliste. Nous avons 2 grandes résolutions à la Commission. Quand je suis arrivé à la Commission, je trouvais que la résolution 275 existait. Non seulement cette résolution protège les activistes qui travaillent dans ce domaine-là, mais elle dit également qu'il faut protéger cette minorité qui est subie de l'injustice dans plusieurs pays d'Afrique. Donc, la résolution 275 existe. Vous l'avez très bien dit, je suis d'accord avec vous. Ça protège les violences contre les LGBTQI+, ça protège aussi les violences, donc les actes de violence, ça protège aussi tous les activistes qui travaillent dans ce domaine-là, conformément à l'article 2 de la Charte sur la non-discrimination. Alors, ça n'a pas évolué depuis lors. Mais moi, je peux vous dire que j'ai fait avancer cette cause alors que lorsqu'existait 275, la communauté LGBTQI+, n'était pas trop satisfaite de cette résolution uniquement à cause des différentes interprétations qu'elle peut appeler. Mais nous avons aussi sorti, même si vous la qualifiez de générale, la résolution 552, qui est le fruit des débats que j'ai eus, beaucoup de débats avec le professeur France Willion sur la communauté intersexe, sur la population, la partie d'Afrique des personnes qui sont intersexes. Je vous avoue que ce n'est pas facile. Il faut parfois apprécier le travail que nous faisons. Moi, j'ai pris cette cause à bras le corps, je l'ai amenée auprès de mes pairs commissaires, j'ai expliqué c'est quoi l'intersexualité, qui n'est pas à confondre avec l'homosexualité. Je crois que c'est déjà un premier pas. J'ai une commissaire à côté qui venait d'arriver, elle s'est présentée comme une des plus jeunes commissaires, elle sait comment cela a été difficile, rien que le mot intersexe. L'expliquer à tous les commissaires qu'on ait la même vision et qu'on aboutisse à voter une résolution. Elle se souviendra que le jour où on a adopté cette résolution, c'était en mode virtuel. J'étais en train à la fois de conduire un véhicule et à la fois en train de participer au débat sur l'intersexualité, laissant à la vice-présidente le soin de diriger les débats parce que je ne pouvais pas au même moment conduire le véhicule et diriger les débats. Et il arrivait des moments où c'était tellement chaud. Il fallait que je garde mon véhicule de côté, que j'écoute et que j'essaie d'expliquer aux collègues. Prenez le rapport que le professeur France Willion nous a envoyé, parce qu'ils ont envoyé un rapport, une étude qui avait été envoyée. Regardez à tel endroit la question que vous posez, voici la réponse telle qu'elle figure. Mais si vous avez des arguments contraires, donnez-les. La manière dont cette résolution était conçue et la manière dont on est arrivé à la fin, c'était un grand effort. Il y a des choses qui ont été enlevées, il y a des choses qui ont été maintenues. Je crois que c'est une deuxième victoire qu'il faudrait prendre faudrait pas considérer cette résolution comme quelque chose de très simple. C'est quelque chose qui vient du cœur des commissaires qui ont compris que l'intersexualité, c'est une autre cause, même si elle est rattachée à celle. Au départ, l'intersexe, c'est quelqu'un qui est né de manière un peu différente, même si par la suite, la cause qu'il peut défendre sur l'orientation sexuelle peut rejoindre l'autre communauté des autres personnes, mais il a fallu expliquer ça aux commissaires. Et le jour où ils l'ont compris, ils n'ont pas hésité de protéger cette partie des Africains qui souffrent de ces handicaps dont beaucoup de gens ne connaissent pas, que beaucoup de gens n'en parlent même pas. Il y a même des familles où c'est caché au niveau de la famille, c'est-à-dire c'est la famille restreinte uniquement qui connaît, les autres membres de la famille ne connaissent pas. Les problèmes que pose l'intersexualité, ce sont des problèmes que les commissaires ont considérés comme étant très graves, qu'il fallait les protéger. Maintenant, on évolue. Je peux vous affirmer que 275 protège, moi je ne cherche que quelqu'un qui va me dire le contraire, 275 protège la communauté LGBTQI+, de la même manière que nous, qui ne sommes pas de cette communauté, nous sommes protégés par la charte. En fait, 275 dit quoi? Arrêtez de discriminer ces gens, ils sont protégés par la charte africaine des droits de l'homme et des peuples. Moi, je pense que le seul problème qui s'est toujours posé, il reste un élément qui se pose, vous l'avez si bien dit, c'est le droit à l'orientation sexuelle. C'est à ce niveau simplement que se pose le problème. Mais sinon, du premier article, du préambule, jusqu'à la dernière disposition de la charte, la communauté, la commission est prête. Elle ne l'a jamais caché à protéger la communauté. La réalité, c'est simplement le droit à l'orientation sexuelle qui pose problème. Alors, quelle est l'analyse actuelle? C'est là où la société civile doit travailler. L'analyse actuelle, c'est de dire, les commissaires ont fouillé la charte du début à la fin, ils l'ont lu. C'est eux qui ont reçu le mandat de l'interpréter, ils l'ont lu du début à la fin, ils n'ont pas vu ce droit-là. Scientifiquement parlant, lorsqu'ils reviennent vers l'Afrique, ils prennent le micro, ils disent, nous ne voyons pas ce droit ici à l'intérieur. Ils n'ont pas tort. Ils ont raison scientifiquement parlant, parce que ça ne figure pas noir sur blanc dans le texte. Je sais, l'opinion de la société civile, c'est de dire que la Commission a toujours protégé des droits, même ceux qui n'existent pas. Elle a pu créer, par exemple, le droit au logement, qui n'existe pas. Elle peut aujourd'hui dire, ben, même si ce droit n'existe pas, je le protège quand même. Mais il faut trouver des commissaires. Il faut les sensibiliser, les mobiliser, de dire, nous acceptons que ce droit qui n'existe pas puisse être protégé. Ça ne passe pas comme ça, comme une lettre à la poste. Réunissez 6 commissaires qui feront la majorité si jamais il y a vote sur le 11 pour qu'ils le disent. Et je vous dis que ce n'est pas facile. Je parle en tant que président, ce n'est pas facile. Me convaincre moi-même en tant que président et convaincre 5 autres sur cette question-là, ça ne va pas être facile. Il faut qu'on en parle assez régulièrement sans que personne ne se sente fâché, qu'on discute entre nous. Ce n'est pas une question taboue, on doit en discuter. Je voudrais terminer par un élément. Les valeurs culturelles africaines, valeurs et traditions. Je peux vous avouer que je pensais que cette question de valeurs et traditions africaines, c'était de la blague. Ce n'est pas de la blague. J'ai lu beaucoup de manuels. La charte africaine a été conçue non pas pour que nous copions les droits qui figurent dans la Convention européenne des droits de l'homme et des libertés fondamentales, pas pour que nous copions les droits qui figurent dans les conventions des Nations Unies ou la Déclaration universelle des droits de l'homme. Les pères fondateurs ont voulu que nous puissions adhérer à la communauté des droits de l'homme, mais en gardant un tout petit peu ce que l'Africain a de plus fondamental, c'est-à-dire ses propres valeurs. Nous n'avons plus de valeurs en Afrique. Toute l'Afrique a été colonisée, excepté l'Éthiopie. Le peu de pays qui nous restent, allez voir, les gens n'ont plus de valeur. Ils ont des valeurs. Hier, quelqu'un nous a parlé ici du Kenya, du Commonwealth, ainsi que des dégâts qu'a causé la colonisation. face à cette communauté. Ce n'est pas qu'une réalité kenyane, c'est une réalité qui existe partout. Lorsqu'on crée l'Union africaine, on cherche à ce que nos valeurs ne se perdent pas. Je peux vous dire que dans l'Afrique, ne parlons pas seulement de l'orientation sexuelle, nous avons perdu beaucoup de nos valeurs. Voilà pourquoi les pères fondateurs ont voulu que lorsque vous allez interpréter ces droits qui figurent dans la charte, s'il vous plaît, n'oubliez pas de protéger nos valeurs. Nous avons le droit de protéger nos valeurs. Maintenant, ça ne se pose peut-être pas que pour l'orientation sexuelle, ça se pose dans beaucoup de domaines. À chaque fois, on doit se poser la question, est-ce que les valeurs africaines permettent qu'on fasse de la non-discrimination? Oui, on ne discrimine pas en Afrique. Allons-y. Est-ce que les valeurs africaines permettent qu'on protège l'environnement? Oui, on protège l'environnement. C'est comme ça qu'il faut lire la charte. Maintenant, si je dis que la résolution 275 protège les LGBTQI+, c'est avec les valeurs africaines comprises. On ne peut pas changer les valeurs africaines. Maintenant, la phrase comme quoi les valeurs africaines ne peuvent pas constituer la base pour nier les droits des LGBTQI+, c'est aussi éliminé dans ce cas-là 275. On ne peut pas prendre 275 dans ce qu'il a de bon, il protège les LGBTQI+, plus les valeurs africaines, et arriver au niveau des valeurs africaines et dire que ces valeurs africaines nient les droits des LGBTQ+. Ça va de pair. Mon conseil que j'ai toujours donné, allons-y lentement. Il y a 5 ans, 6 ans que je suis arrivé à la commission, on ne parlait même pas d'intersexe. Aujourd'hui, on a évolué, ils sont là. Demain, on peut prendre une autre catégorie. Essayez d'expliquer. Mes frères et sœurs, voici comment les choses se passent, voici comment ça peut aller. C'est un petit combat, on gagne. Un gâteau d'anniversaire, on ne le mange pas en entier. Hein. On coupe morceau par morceau. On coupe morceau, on donne à quelqu'un, il mange. On coupe un morceau, on donne à quelqu'un. Et ainsi de suite, jusqu'à ce que le gâteau sera fini. Je n'ai jamais été dans une fête d'anniversaire ou de mariage où le gâteau est resté. On finit par le manger tous. Alors, coupons morceau par morceau. Si on a coupé dans LGBTQI+, on a enlevé I. On a dit protégeons les I parce que regardez, c'est un peu différent. Continuons à travailler ensemble. Demain, on trouvera autre chose. Je voudrais que l'Afrique garde une bonne image, la Commission africaine, auprès de tout le monde, auprès de la Commission. Nous sommes au milieu. N'oubliez pas que les créateurs de cette institution, c'est d'abord les États. C'est pour ça que je vous ai dit au début, les représentants des États ne sont pas là. Allez aussi leur poser la question, quels sont leurs points de vue par rapport à cela. Et c'est là où ça m'amène à la dernière observation sur le retrait du statut d'observateur. Je peux vous avouer que chaque fois que j'arrive en Afrique du Sud, je me prépare. CAL n'est jamais fini. Et je suis peut-être le commissaire qui a le plus répondu sur CAL que d'autres. Je suis arrivé à la commission. On avait déjà accordé et retiré le statut de CAL. Je suis solidaire avec les anciens commissaires. Je ne peux pas me désolidariser de la décision qui a été prise, mais je la comprends. Je comprends que ça frustre CAL, mais c'est compliqué. Pourquoi ça frustre CAL? Restons clairs. Vous parlez souvent des décisions du conseil exécutif. Ne dites pas conseil exécutif, dites les États. Ce sont les États qui ont dit, nous vous rappelons à l'ordre, c'est nous qui avons pris les engagements pour la charte et nous pensons que les engagements que nous avons pris doivent aller de pair avec les valeurs africaines. Nous ne voulons pas qu'on puisse promouvoir un droit. Lequel? Ils n'ont pas dit enlever les autres droits. Ils ont dit nous ne voulons pas qu'on promeuve un droit. C'est ça les débats quand moi j'essaie d'écouter les débats tels qu'ils s'étaient passés chez les États. Nous essayons de promouvoir, nous ne permettons pas qu'on promeuve un droit qui ne figure pas dans la charte et qui ne cadre pas avec les valeurs africaines. Et cette logique est en train de continuer jusqu'aujourd'hui. Comme je l'ai toujours dit, le président qui a présidé la session où Synergia de Stéphano, mon ami Stéphano, ou bien Alternative Côte d'Ivoire et des autres, c'est moi qui avais présidé les débats au cours qui ont conduit à ce qu'on refuse le statut d'observateur. On a refusé que sur la question de la promotion du droit à l'orientation sexuelle. Croyez-moi, si Synergia revient avec un autre projet, il aura son statut d'observateur. On le refuse que sur cet élément précis. Mais si Synergie, si Alternative veulent promouvoir les autres droits, ils peuvent le faire. C'est ça que je voulais apporter comme message, comme clarification. Le seul problème qui nous oppose, qui n'est pas encore résolu, c'est la question seulement de l'orientation. L'orientation sexuelle, simplement. C'est juste ce droit-là qui pose problème. La société civile est appelée à continuer à y travailler. Ça, ce n'est pas mon travail. Peut-être demain, je retournerai à la société civile. Mais aujourd'hui, je suis président de la commission, je suis commissaire, appelé à interpréter la charte de la manière la plus évolutive possible. Et je vous ai même donné une piste, mais vous êtes limité, nous sommes aussi limités. La manière la plus évolutive, c'est-à-dire la société civile nous a déjà rappelé, vous faites de l'interprétation dynamique de la charte. Certains droits qui n'y étaient pas le sont aujourd'hui, sont protégés aujourd'hui, comme le droit au logement. Prenez votre courage, allez jusqu'au droit à l'orientation sexuelle. Mais ce courage-là à prendre, il n'est pas automatique. Il faut un plaidoyer. Et j'ai même donné la dernière fois, il y a quelqu'un qui est ici, avec qui nous avons tenu une réunion à Banjul, le modérateur d'hier. Comment il s'appelle? Le modérateur d'hier avec qui nous étions. Il s'appelle? J'ai eu une réunion à 3 reprises avec eux la dernière fois à Banjul. Curieusement, c'est même moi qui donne les idées. Je leur ai dit, comme pour les autres causes de l'Afrique, prenez une personne que je ne vois pas aujourd'hui. Une personne qu'on appelle, à l'Union africaine, on les appelle des champions. Avez-vous déjà trouvé un champion de cette cause qui va faire pays après pays pour en discuter? Un ancien président qui est également dans la communauté LGBTQI+, ou bien un ancien premier ministre qui devient champion de la cause, qui commence à l'expliquer publiquement comme cela doit se faire. Je n'en vois pas. Trouvez-en un qui fait ce boulot. Ce n'est pas moi qui vais faire ce boulot, mais le boulot de promotion, c'est vous qui devez le faire. Si vous en avez les capacités, cherchez des champions qui vont vous aider, qui vont faire comprendre la cause. Voilà ce que je voulais dire entre cette communauté et nous. Je crois que nous avons des relations de bonne entente, des relations de cordialité, et la commission sera toujours là pour les protéger, conformément à la résolution 275, conformément à la résolution 552, pour toute la charte, ils doivent en bénéficier totalement. Violence contre eux, c'est refusé. Le seul élément qui cloche, c'est la promotion du droit à la. Et puis, quand on dit on refuse le statut d'observateur, ça signifie quoi? Disons-le de manière concrète. Ça vous donne droit à quoi? On est pendant la session, le statut d'observateur, c'est celui qui vous permet de prendre la parole et de défendre une cause. Mais si vous venez pour défendre ce droit-là, on va vous dire non, ça n'existe pas, on en a déjà parlé. Mais si vous venez même Synergie pour défendre le droit au logement des LGBTQ+, je ne vois pas comment la commission va dire non. Ils sont discriminés, on ne leur donne pas le logement parce qu'ils sont. La commission va dire non. Nonobstant cela, ils ont le droit au logement protégé par la charte. Ils sont discriminés, on ne veut pas qu'ils participent au vote. La commission va dire non, ils doivent voter, ils doivent être élus. Mais c'est uniquement cet élément-là, comme je le souligne aujourd'hui. Je veux que les choses soient claires. Je le dis au nom de tous les commissaires, au nom de la commission. Et permettez-moi, Madame la Présidente, ma collègue, donnez-lui même 2 minutes, qu'elle me complète avec 1 ou 2 éléments sur cette question. Comme ça, vous avez la police des débats. Vous savez ce que nous pouvons faire de tout ce que nous avons dit. Colette.
Thank you very much, Chairperson, for yielding your floor to me. I would have liked to take the floor substantively to comment on the 2 presentations, but right now I just want to add to what the Honorable President has said. I think you have covered everything. I have very little to add. But just to say that the intersex debate seized us seriously. And the fact that it was based on research that was undertaken actually by the center made it possible for us to really delve on the matter. But, you know, this, the intersex matter is very different from the others because people are born that way. I think colloquially it's known as, it's got a term. When people are born intersex, we have a term for it. Hermaphrodite. Yeah, hermaphrodite. That's how colloquially it's termed as. So people are born that way. We know the term is not light. We have gone deeply into even why the word is not used, but colloquially, we are talking about Africans. This is how we know it in the village. And so this is a fact that we had to deal with in coming to take the resolution 553. But I just wanted to say that the issue of LQ, it's a long alphabet,
LGBTQ
has been politicized. It has been removed from the cultural domain. These sexual issues, according to African culture, are very personal, and they have moved from their domain to the public domain, and now they have moved to the political domain. And this has not helped this debate. And I want to say that the fact that some conditions have even been put for funding in our member states has really irritated our member states. And that is what has taken now this whole matter to the political domain. So where it is very difficult even for the Commission to contain. So we keep left, we do what we are supposed to do. We do not want to get involved in the politics that this debate has been pushed to. And I think from Commission point of view, we do what our member states have mandated us to do. And we are champions of human rights, so we try our best to illuminate what needs to be illuminated. But what I can why I took the floor is to say that this matter has now left both the public domain and has gone to political domain, and it is now out of our hands. And it is very difficult for us even to be able to contradict the scenario, what's happening in the continent. I also wanted to talk about, very briefly, about shared values. We had a whole year, I think it was 2017, when the theme of the African Union was shared values. And one of the things we discussed is, yes, we were colonized, we've lost so much. What is left for us to hang on to? And African values is one of the things that we felt we have not lost through colonization. And we are going to try our best to, because this is what we know, to at least hold on to the values. And these values have even contributed to, we have contributed our shared values to other regions of the world. It's not that other regions of the world have got better values, by the way. Some of the values that we receive are not really that good. And so we are saying maybe we are the continent that has something to contribute, and this is shared values. And so we are in our corner, and we are trying to salvage the little that was left by colonization. And we are saying, please take us slowly. And that's all I wanted to say. As a director for gender and women for many years at the African Union, I was challenged about harmful traditional practices that we were practicing as a continent. And we tried to listen and we tried to deal with them. And FGM is one of them, harmful traditional practice. And we admitted that we said, yes, this is a harmful traditional practice, and we try to deal with it. I want to say that all the values that we get from outside are not non-harmful. Some may be harmful, just like ours have been harmful. And so let us also be smart as Africans to choose what cultures add value and what cultures do not add value. We just released a press statement on the Gambia, trying to reverse legal provisions on FGM. And we are very proud to do this, to fight to tell our government, look, you had said FGM is not good, now you cannot go back. And so we are ready to fight where we believe that African values are at stake, and also where we feel that African values are harmful. But where they are not harmful, let us not start a fight. I thank you.
Thank you very much, Honorable Chairperson, Honorable Dr. Rita Musimi, for your reflections on the work of the African Commission on LGBTIQ people, intersex African values, and the status of observers of NGOs. Unfortunately, we have no time left, but if Poluso allow me, I would like to give the opportunity to the participants to ask questions and also the panelists to react. So I have the permission, so we have 15 minutes. So I will say 10 minutes for participants and 5 for our panelists, okay? So I see 2 hands, so please proceed. First you and then 1, 2, 3. I will ask you to be a little bit brief.
Thank you very much, Chair. I've got one question that goes to both Dr. Ghosh and our commissioners. We've heard a lot about African values, but substantively, nobody has actually told us what these values are. So what are these African values, and how are these values incompatible with sexual orientation or gender identity? Thank you.
Thank you. Then please, the other person, go ahead.
My friend actually just almost asked the question I wanted to ask, but to add on it, one of the shared values that I know of Africa is tolerance, acceptance of diversity, principles of Ubuntu. And also, if we really have to go back to the issue of African shared values, one of the things we notice that Africa as a continent has been sexually diverse, but that is a distortion that has been made over time. So if we have to really go back into history, one of the things we notice is that Africa was tolerant of diverse sexuality. So I just wanted to get a comment from the commissioners as to whether that is something that can be embraced in the context of equality and non-discrimination for all who are within African states, African societies, and who fall under the African Charter. Thank you.
Thank you very much. I saw this sister.
Thank you very much. And thank you very much also for the presenters, for their great presentations and also the enlightenment that we received from the respondents, which was really, really helpful. I have 2 questions. First to the Namibia speaker. You know, when you were speaking, I was like, I think I need to move to Namibia, huh? It seems to be a utopia there in terms of human rights. But I think just to highlight, and I'm also very happy to hear that you considered some of the Amnesty reports as part of your work. That was great to hear. And I acknowledge that you did recognize that Namibia has some way to go when it comes to the protection of the rights of indigenous San people. And this remains a problem that's quite persistent, as you highlighted, with very slow, if any, progress, especially with regard to accessing health services. For example, with people living with tuberculosis and just being able to access basic healthcare services, leading to quite a lot of unnecessary deaths of this community. So are there opportunities, in your view, to advance this matter, whilst you acknowledge that you lag behind as a country when it comes to this, especially when you come to talk about the regional level? Are there opportunities to move forward with this and to really pick up a pace so this community is not left behind? And then with regard to the second speaker, I think that matter has been quite in-depth ventilated, but I appreciate some of the opportunities highlighted by the speakers. for civil society to try and move this matter forward. I appreciate what especially the chairperson has highlighted, that there are indeed some ways in which we as civil society can try to advance this matter. In particular, I think we probably have a contribution to make in helping and taking people along with us when we, highlight that it's not that civil society or rather LGBTQ activists are seeking for the recognition of the right to sexual orientation. That is not necessarily what is being asked for. That we're not saying the charter needs to say everyone has a right to sexual orientation. Everyone is born with the sexual orientation, irrespective of whether they are LGBTQ or not. So we need to just try and clarify that for the community. But I also want to quickly emphasize that, like in the Latin America context, there's been progress with strategic litigation, where, for example, victims of torture based on their sexual orientation have, at the highest level, at the regional level, received recourse. And it's unfortunate that there's not a single case at the African Commission that has come on this particular issue of violence which persists. So what can we do, and how can we elevate this matter to that level? Because you highlighted there are resolutions which could help us to actually get the justice that we require for this particular problem of violence. Thank you.
Thank you very much. I would like also to give the opportunity to those who are joining us online. Is there any question? There are no questions for the people who are online. No. So please, this is the last question. The last question, and then I will give the opportunity to the panelists to react. Thank you.
Thank you very much, Chair. So my first reaction is, I think it's just directed to the chairperson on the issue of disseminating the intersex reports, where we work jointly as a center with the Commission, that we are actually in fact planning, at least I think as we discussed last year, to have a session on the sidelines of the African Commission session, so that we popularize it, especially with the state delegates who might be attending this session in Arusha as part of civil society efforts to raise awareness. And then I wanted to also react to my brother from Namibia. Thank you so much. And when we visited Namibia, when to talk about ratification of the Disability Protocol, we also spoke about ratification of the African Court Protocol. So, and I think one of the things we faced, especially with the South African government, they were saying that we have advanced courts in South Africa that are addressing human rights challenges, and therefore ratifying the court protocol and actually submitting ourselves to the jurisdiction of the court would be superfluous, because we already have, mechanisms at the domestic level. But I think our view as civil society and members of academia is that, there will be many other things that courts at the domestic level might not effectively address. And I think the issue of indigenous people's rights in Namibia is one of them, for instance. And also, when President Zuma was sent to prison by the Constitutional Court in South Africa, he was now saying, I've briefed my lawyers to approach the African Court, but he forgot that he had not signed that 34-6 declaration. So what that tells us is that, you might have very good institutions at the domestic level, but there might be certain other issues that might not be fully addressed. Yeah. So I just wanted to say to you, maybe I think Namibia could act as a champion as well as South Africa in ratifying the court protocol. Thank you very much.
Thank you. So I will give the floor first to Ghosh, then to you, and then the chairperson, if that's okay with you both.
Chairperson, thank you so much for your comments, and for everyone from the Commission who added to it. From what I could understand, there are ways of circumventing certain issues and presenting the issues at the African Commission at the same time. And that is one way forward that we can look at. But at the same time, we should be careful not to subtract queer people from the notion of African values. I can understand when you say that it is more of an area of culture and personal space, and it has become politicized now. But at the same time, the politicization has happened because of the invisibilization and the criminalization that has been carried out. For all we know, all the criminalization is a result of colonization, but that cannot be entirely the case. There's also a lot of ground level realities around the criminalization, around the hatred that is spread against queer people. So, and it is spread on a daily basis. We can see the Kenyan situation where the Supreme Court is trying very hard to stop certain things from happening and, rights sliding backwards. But at the same time, we have the Ugandan situation where the parliament is taking stricter steps towards criminalizing queer people. So in these situations, while I totally agree that we should approach the union, approach the observer status in a way where we look at different issues, as you mentioned, housing for LGBTQI plus people, instead of looking at the right to sexual orientation. I have to concur with my sister over here who said that, we are not looking for the ratification of the right in the charter, but we are looking for overall protection where the expansion of a given right includes queer people. It is about the interpretation that we are looking for, and the interpretation has to come out further in more resolutions. Currently, the resolutions are very limited in their wordings, and it is difficult to work with them. However, 552 has been exemplary in many ways. It has definitely opened many more doors in the way we can look at including LGBTQI rights on various platforms. And in fact, when it comes to a case going up to the African Court of Peoples and Human Rights as opposed to the Inter-American Court, how is it that there's been no case around LGBTQI rights there? In Angola, the current test case that is going on will soon include a passage from Resolution 275, which, if I may read out, the Commission strongly urges states to end all acts of violence and abuse, whether committed by state or non-state actors, including by enacting and effectively applying appropriate laws prohibiting and punishing all forms of violence, including those targeting persons on the basis of the imputed or real sexual orientation or gender identities, ensuring proper investigation and diligent prosecution of perpetrators, and establishing judicial procedures responsive to the needs of victims. As the legal case moves forward, given the fact that it was the Luanda session that passed this resolution, it would be interesting to see what happens, and if the case does go up to the African court and the domestic court doesn't actually come to a resolution around it. But till we have more test cases like this, it is very difficult for us to just litigate and provide a solution at the African level. It has to be at the state level, which is why we need more proactive actions from the Commission itself. Thank you so much.
Thank you very much. Mr. Petrus Hatupopi, you have the floor.
Thank you very much, Doctor, for the opportunity to respond to the question. I think the first question relates to the promotion and protection of the rights of indigenous people, insofar as their right to health is concerned. And I would just like to give you practical examples of what the government is doing or has been doing in the recent years to ensure the promotion and protection of the rights to health of indigenous people. When we obtained independence in 1990, the office of the Prime Minister, and it was Dr. Libertine Amadila at that time. Maybe you can search up her work in the promotion and protection of the rights of indigenous people. She has done remarkably well. She was the Prime Minister at that time, and she was present on the ground. She has gone out to reach out to the indigenous people. We have over Twe, over Demba, over Chimba, and the San, and she wanted to find. She wanted to find ways to address their plights based on what they want. Because sometimes what we have realized with our indigenous people, we impose. We don't really consult them to ask them what exactly do they expect from the government, or what are the ways that you can use to improve their living conditions. So she went out. Reached out to them, and they made various recommendations on how they want the plight to be addressed. And she managed to get funds from the government and from various donors. And she went out to establish schools, buy school uniforms, establish farms for the indigenous people in various areas where they are. They didn't try to relocate them. They didn't try to build for them structures that they do not want. So that's one way that we have that the government has done to address the plight of the indigenous people. And also with regard to health, now the Office of Indigenous People has been moved to the Office of the Vice President. So there's a department in the Office of the Vice President dedicated to the plight of indigenous people. And they've tried to work in consultation with the Ministry of Health to ensure that there's outreach programs to go out and take health services to the indigenous people where they are. And they've also tried to send the Ministry of Home Affairs, Immigration and Security to go out and address the issue of statelessness, to ensure that indigenous people are registered and have national identification documents. And also, one thing also to mention is that in Namibia, public health is free, but there's a voluntary fee of $5, which is equal to 5 rand. But some people are not expected to pay that. So they have free access to that as well, and also free access to education as well. So those are the issues those are the measures that are in place, practical measures in place to address the plight of indigenous people. And okay, thank you. And there's also social grants. They qualify for social grants, but they need to be registered first and have national documents for them to have access to social grants. So those are the practical measures in place to ensure the access to health and promotion and protection of human rights. And also the issue of ratification of African Code Protocol. Namibia signed the protocol on the 9th of June, 1998, but unfortunately up to now, we have not ratified. And this is one of the recommendations that has been repeated in all the concluding observations of the Commission, but up to now, there's no explanation. And as you have correctly said, we need to ratify this and be an example to other African countries. So yeah, thank you.
Thank you very much, how to Poppy. So now I will give the floor to the Honorable Chairperson. You have the floor, please.
Merci encore à Madame la modératrice. Très humblement, je ne voudrais pas donner l'impression que j'ai la réponse à toutes les questions qui sont posées, mais je vais essayer de les rencontrer toutes parce que nous sommes ici pour parler de la Commission. La première question, quelles sont ces valeurs africaines? Où se situent certaines compatibilités dont vous parlez par rapport à ces valeurs africaines? Croyez-moi, les commissaires ne dorment pas. À la session passée, nous avons discuté de ces valeurs africaines et fort probablement, nous n'avons pas épuisé ces débats. Nous avons déjà des documents en interne bien rédigés depuis longtemps d'ailleurs. Madame Abiola, qui est ici, elle peut vous dire que ce genre de documents existe, des réflexions sur des valeurs africaines, des études qui ont été menées également par la Commission et ne prend pas cette question à la légère, la charte ne les ayant pas définies. Nous sommes en train de mener nos propres recherches internes pour découvrir quelles sont ces valeurs. Madame Abiola, qui est là, est en train de... Elle nous a déjà présenté un premier document. Abiola, c'est ça, non? Nous avons déjà discuté sur un premier document et nous sommes en train de discuter encore sur la suite parce que si tout va bien, d'ailleurs, ça pourrait être inscrit à l'agenda qui arrive, mais ce sont des documents qu'on ne partage pas encore. Ça reste des documents internes au niveau de la Commission. Faites vos propres recherches sur ces valeurs africaines. Personne ne peut vous les donner. La Commission ne peut les inventer, mais elle doit aller les chercher là où elles sont. Elle doit aller les puiser là où elles sont. Ça demande des gros moyens et des grosses recherches. Ça demande du temps. Nous les cherchons tous ensemble. On ne sait jamais tout. Je crois que j'avais promis ça, qu'on cherchera où sont ces valeurs. Je pensais innover, mais je me trompais parce que mes prédécesseurs, les anciens commissaires, faisaient déjà cet exercice aussi. Et on trouvera s'il y a une compatibilité ou pas. S'il y a une compatibilité ou pas. Je sais déjà. Je ne parle pas à la légère. Je sais déjà, qu'on m'a déjà dit, ayant discuté déjà de cette question, qu'on aurait retrouvé. Ça, c'est la société civile au LGBTI qui le dit. Moi, je ne le prends pas comme une lettre à la poste. Je ne le prends pas pour affaire comptant. Je suis chercheur, je vérifie. Les commissaires sont des chercheurs, ils vérifient aussi. ils disent qu'ils auraient déjà trouvé dans les traditions africaines des empreintes de ces valeurs d'homosexualité. Je parle comme professeur d'université ici. Mais nous devons aussi interroger les mêmes sources et savoir ce qu'elles disent. Parce que vous pouvez avoir une source d'information, chacun lui donne l'information qu'il veut. Nous aussi, nous cherchons ces mêmes sources. Nous voulons savoir ce qu'elles disent. Et puis, nous allons les confronter à nos propres sources pour savoir si elles sont vraies ou pas. Le fait qu'elles proviennent de la société civile n'est pas une carte, un chèque en blanc directement. La commission fait ses recherches et c'est notre mandat, selon l'article 45, de mener des études. Nous avons très peu de moyens, nous le faisons à notre rythme, mais nous continuons à mener ces études. Ces valeurs partagées, shared values, vous dites la tolérance et la diversité sont également des valeurs partagées et vous faites une assertion que je respecte. L'Afrique est diversifiée dans le cadre de l'orientation sexuelle. Je n'en doute pas. Je ne peux pas en douter. Si l'Afrique est diversifiée dans le cadre de l'orientation sexuelle, ce n'est pas le fait de le dire qui correspond exactement à ce qui se trouve dans la société. Laissons la société s'exprimer. Allons dans tous les pays, disons-leur, vous êtes diversifiés, pourquoi vous refusez ceci? C'est le feedback que nous aurons qui va être la vraie réponse par rapport à ça. Comment vous savez qu'elle est diversifiée alors que vous n'avez pas fait toute l'Afrique non plus? Vous devez savoir que la commission telle qu'elle est là, c'est 5 régions d'Afrique. Nous, au moins, la société civile qui a souvent l'habitude de parler, elle est basée d'un côté. Mais nous, au moins, quand on parle à 11, la voix que donnent les 11 commissaires, c'est 5 régions, le nord, le sud, l'est et l'ouest. C'est toutes les religions. C'est le catholicisme, le protestantisme, l'islam. Et tout ça, il faut mettre ensemble avant de venir dire cette valeur, elle passe ou elle ne passe pas. Et dans nos débats, vous devez savoir que nous sommes influencés par nos origines, nord, sud, est, ouest ou centre. Nous sommes influencés par les religions qui sont les nôtres, les religions que j'ai citées ici. Mais je crois que ceux qui ont conçu cette commission de cette manière et cette représentativité, ils ne vont pas y tort. C'est pour qu'après débat, on puisse trouver le juste mesure, le juste milieu. Donc, je vous crois quand vous dites que c'est diversifié dans le cadre de l'orientation sexuelle, mais laissez-nous terminer notre travail que nous faisons aussi sur les valeurs et traditions africaines. Nous verrons si cette diversification existe bel et bien. Le jour où nous allons avoir nos conclusions par rapport à ça, ça peut ne pas être moi, parce que je ne serai pas éternellement président. Quelqu'un d'autre viendra dire, voici ce que notre étude a démontré par rapport à cela. Et si c'est nous qui nous trompons, nous allons le reconnaître, changer de point de vue. Si c'est les États qui se trompent, on va leur dire, vous vous trompez parce que voici ce que nos études ont démontré. Si c'est la société civile qui se trompe, on ne manquera pas de lui dire, vous vous trompez également à cette question. Je termine par la question de la litigation. Nous luttons toujours pour que les ONG, qui sont les apporteurs de communication ou de plaintes au niveau du système judiciaire africain de droits de l'homme, puissent travailler correctement. Ce n'est pas à nous de nous plaindre. C'est pas à nous de nous plaindre. Nous attendons qu'on nous saisisse sur les cas qui ont été jugés sur le plan national, sur l'orientation sexuelle et qui n'ont pas abouti et qui arrivent chez nous. Qu'est-ce que nous en disons? C'est ça notre job. Votre job à vous, en tant que société civile, c'est d'encadrer ces cas devant le juge national qui est le premier responsable à se prononcer sur cette question. Si ce juge faillit à sa mission et que vous n'êtes pas satisfait par rapport à vos prétentions, vous arrivez maintenant devant la commission, vous écoutez notre lecture. Il y a très peu de cas sur l'orientation sexuelle, mais ce n'est pas à nous de les créer, ce n'est pas à nous de les inventer. Et dans tous les cas, disons-le, 30 ans d'existence de la commission, c'est moins de 1000 communications. Si on ne devait que s'en tenir à ces chiffres, nous pouvons dire, comme on l'a dit pour la Namibie, il n'y a pas de violation de droits de l'homme en Afrique. Parce que si en 36 ans d'existence, nous n'avons que 1000 communications à la commission, donc le taux de viol, de violation de la charte est presque de 0%. Si on doit diviser en termes d'années et autres, vous regardez 54, 55 pays, vous divisez par le nombre d'années de la commission elle-même, 36 ans, vous divisez par le nombre de mois dans l'année, vous verrez que le taux est de 0%. Ça signifie que l'Afrique se porte très bien comparativement aux autres. Donc, méfions-nous des chiffres, même s'il n'y a pas, ça ne transparaît pas, ça ne montre pas clairement la situation de l'Afrique. Le mot de la fin, pour moi, je serai complété par ma collègue, mais en ce qui me concerne, je n'interviendrai plus. L'Afrique se porte bien. Une charte existe pour protéger tous les Africains. Quand la charte protège les Africains, ne regarde pas. Celui-ci, il est lesbienne, celui-ci, il est gay, celui-ci, il est queer, celui-ci, il est transgenre, celui-là, il est intersexe. Non. La charte ferme ses yeux et dit, je mets un bandeau noir, je vous protège tous. C'est ce que fait la charte. Et c'est ce qu'on m'a dit de faire. Et c'est ce que j'ai toujours fait, c'est ce que j'ai étudié. Et nous protège tous. Ça, c'est d'abord un. Maintenant, il y a des minorités qui ont besoin de quelque chose de spécifique. Quand ces minorités arrivent, nous donnons une première réponse. 275. Les gens disent, nous ne sommes pas satisfaits, mais nous apportons les réponses. Attention, vous n'êtes pas les seules minorités. Et les minorités ne sont pas que sexuelles. Il y a des minorités financières qui existent dans cette Afrique. Il y a des minorités qui existent dans plusieurs autres domaines. Plusieurs minorités existent. Mais vous êtes déjà une minorité catégorisée qui est protégée spécifiquement par une résolution. Parce que si on part dans le terme des minorités, je peux vous en démontrer beaucoup ici. Ce combat n'est pas terminé. Même si les gens ne sont pas contents avec 275, les choses ont évolué. Moi, je suis très fier aujourd'hui d'avoir fait évoluer cette cause. J'ai offert à l'Afrique la résolution 552. J'en étais le promoteur, après avoir bien étudié la question. Je pense que c'est un pas qu'il faut apprécier. Et demain, là où moi je vais m'arrêter, c'est la commissaire Lita, ou bien ma collègue Abiola, le jour où elle deviendra aussi commissaire, elle prendra aussi la cause, et elle avancera encore beaucoup plus loin. Restons unis, restons soudés, travaillons ensemble. Cette commission est vôtre et toutes ces questions qui paraissent, qui vous donnent l'impression que vous n'êtes pas suffisamment pris en compte, ce sont des questions qui vous distraient. On est ensemble et cette commission-là est là pour vous. Permettez, madame, ma collègue va me compléter. Elle aime bien ces choses. Comprenez qu'elle a été directeur du genre. Toutes ces questions de valeurs partagées, c'est tout ce qu'elle a fait toute sa vie. Il voudrait ajouter un petit mot sur cette question-là, et puis nous vous remettons la parole.
Thank you very much, Chair, for yielding the floor to me again. I'll just start from where you left and just say, according to Resolution 455 of 2020, on the minorities, we also have ethnic, cultural, linguistic, religious, and regional minorities in our definition. I took the floor because a couple of questions were raised around shared values, and I thought maybe I could just elaborate on this. The African Union held its summit on shared values in 2012. And before the AU summit can discuss on any theme, there is a process that is followed. And this process emanates from member states. First of all, the department in the AUC, in the AU Commission that sponsors the theme. In the case of shared values, it was a political affairs directorate, has to convene first an experts meeting of member states. Member states experts are convened and they discuss the topic. And in this case, in the whole of 2011, the Department of Political Affairs convened a meeting of experts from member states who discussed what are African shared values. After the experts discussed what they thought the shared values were, a meeting of ministers in the African continent, 55 ministers, was convened to discuss what African shared values were based on the experts' discussions. And usually the experts' discussions are based on studies that have been undertaken. And so ministers discussed the shared values extensively. And from there, the report of ministers goes to the PRC, the Permanent Representatives Committee. And the committee discussed these shared values extensively before these shared values were taken to the Executive Council. These are ministers of foreign affairs from the 55 countries to discuss African shared values. And this was done. So by the time the Shared Values Summit was held in 2012 and submitted to the African heads of states, this process had gone through a thorough process. I want to encourage my colleagues here to Google, to go into the African Union website and see what were the discussions that were held on shared values, because I'll not be able to do justice to you. We are already running out of time. There you'll find deposited in the African Union website all the documents that describes the African shared values and what the message that came out of the 2012 summit to the rest of the world read like, because heads of states took decisions on shared values. So this is what I would encourage colleagues to do: Google, read, and then from there, if you see any gaps and you want to convene another meeting where we can come and look at the gaps that have been left by such a thorough process, then that is something we can discuss. So I just wanted to say that, and thank you.
Thank you very much. I think we took 30 additional minutes. My sincere apologies for this, but I truly believe that this topic deserves our attention. I would like to thank all of you, and particularly the speakers, Dr. Hosh and Mr. Hatu Popi, the Honorable Chairperson, the Honorable Dr. Musimi Ohana, and Mr. Rosa for this very engaging session. Thank you very much.
Thank you very much, Prof. Clara and colleagues on the panel and commissioners for your responses. I think it's a good time to take about 10 minutes tea break so that we reconvene for the next session. Then I've just been reminded the register is still going around. So if you have not signed the register yet, please see Ruth at the back to sign the register. But before we go for our tea break, please a round of applause for our panelists, our chair, and for the commissioners for their responses. So we will reconvene at 25 minutes past for the next session. Thank you.
On the video, do you also want the CSV logo to be a watermark, or is it a CSV at the end and just allow to the watermark on the video? I'm just thinking because I understand that the partnership at all, but they are not aware. Are they aware like we're going to do these videos with them? Yeah, so that might be a thing you want to check with them, but if you're not checking, then maybe you can check with them at the end, because it looks like they've endorsed it to the left hand.
Welcome back, colleagues. Can we please settle down for the next session so we can wrap up the discussions for the conference and have lunch, and before we move over to the afternoon discussions on the different communications. May and Lydia, please, if you're ready with your presentation, please, can you approach? Yeah. So you can have it. Yeah. I think so. You can present from there. Yeah, so we're going to start with a bit of an advocacy interlude by the litigants group and the implementation working group to introduce us to some of the issues or concerns of the litigants group and the implementation working group in terms of their current programming on how the interaction with the commission has been, but also how best the litigants group and implementation working group is thinking about the assistance that they can offer the commission towards the implementation of the commission's decision. So I'm going to hand over to May, Aman, and Lydia over the next 30 minutes to take us through the presentation on advocacy on the implementation of the decisions of the African Commission from the litigants group and the implementation working group. I don't know if Simpiwe is here. There's seems to be some disruption from the online platform. If you can mute yourself, colleagues, on the online platform so that we don't get interference. But over to you, May.
All right, thank you so much, Michael. Good morning, everyone. My name is May Aman. I'm a doctoral candidate at the Center for Human Rights. And I also work with the Initiative for Strategic Litigation in Africa, focusing on strengthening accountability mechanisms on the continent. For today's presentation, myself and Lydia will introduce you to some of the advocacy efforts that are led by the litigants group. And for those of you who don't know what the litigants group is, it's a group of civil society organizations and legal community members who have been working with the Commission for over a decade, actually, with the aim of reinforcing the African Commission's protective mandate. Currently, the litigants group are leading 2 advocacy initiatives that are relevant to the implementation of the decisions of the African Commission. First is the Article 59.3 campaign. And the second one is the implementation working group. I will lead the discussion on the Article 59 campaign. Ms. Lydia will lead the discussion on the implementation working group. So the Article 59 campaign has been conceptualized during the litigants group meeting that took place on the sidelines of the African Commission session in May. The background and rationale behind the campaign is that the Commission's interpretation of Article 59 of the African Charter leads to a rather obscure and non-transparent dimension on the communications procedure. Based on Article 59, actions undertaken by the Commission under the communications procedure are to be kept confidential until authorized for disclosure by the AU heads of state and government. However, the Commission's interpretation extends this confidentiality to include all related records and legal submissions by involved parties. This expansive interpretation prompts the need for a more progressive understanding of Article 59.3 due to its implications on human rights and the participatory role of civil society organization in ongoing legal proceedings. So as a background, Article 59 of the African Commission provides that all measures taken within the provision of the present chapter, which means chapter 3, shall remain confidential until publication is approved by the Assembly of Heads of States and Government. Chapter 3 spans from Article 46 to Article 59, including the communications procedure, which is provided for under Article 55. Article 59.3 provides that the report on the activities of the Commission shall be published by its chairman after it has been considered by the Assembly of Heads of State. So we can see that Article 59, its phrasing allows room for diverse interpretation, especially regarding its interpretation of all measures in Article 59.1. The Commission's interpretation of this phrase includes all actions and communications conducted and received by the Commission. It extends beyond the recommendations and decisions of the Commission to include all facets of communications, including pleadings and individual submissions. This current interpretation results in a profound implications for the protection of human rights on the continent by restricting access to information, thereby impacting on the right to a fair and public hearing, as well as curtailing advocacy efforts related to pending communications, as relevant information remains confidential until, like I said, approved by the Assembly of Heads of States. So in terms of access to information, international human rights standards provide that individuals are entitled to seek, receive, and impart information and ideas of all kinds, and that access to education, education is my other area of interest, that access to information must be easy, prompt, effective, and practical. The UN Human Rights Committee provided guidance on the right to information under Article 19 of the ICCPR, reaffirming that exceptions to the right are limited to those provided under Article 19.3, which pertain to respecting individual reputations, national security, public order, health, or morals. At the regional levels, we find that the Inter-American Commission on Human Rights adopted the Inter-American Declaration of Principles on Freedom of Expression, which affirms the right to information and recognizes it as a fundamental right of each individual. The Inter-American Court on Human Rights has held that the right to freedom of expression includes a right to access information held by public bodies in several occasions. Similarly, the Council of Europe recognizes the right to access to information and adopted the Convention on Access to Official Documents, which obligates member states to guarantee individual access to information. Coming closer to home, the African Commission adopted a Declaration of Principles on Freedom of Expression and Access to Information in Africa in 2019. This document is based on Article 9 of the Charter, which guarantees individuals the right to receive information, as well as the right to express and disseminate information. The declaration provides for a maximum and proactive disclosure of information. The only exception is narrowly tailored, that is in accordance to international human rights standards. Based on this, we can see that the current interpretation of Article 59.3 departs from the principles of publicity and freedom of information as provided for under international standards and under Article 9 of the African Charter. The interpretation also limits the capacity of the wider public, NGOs and CSOs to actively engage with human rights issues pending before the Commission, thus limiting their ability to place pressure on government actions. Furthermore, the current interpretation hampers the participation of interested experts or NGOs in ongoing communications and the submission of amicus briefs due to the confidentiality surrounding the communication information. Rule 104 of the Commission's Rules of Procedure 2020 provide that third parties are allowed to intervene in amending communication, either by invitation or upon request, serving as an amicus curiae, right? To aid the Commission in determining factual or legal issues. However, we see that subsection 3 of the same rule requires the authors of the request to indicate the relevant communication to which the amicus relates, as well as the contribution, the proposed amicus to the ongoing communication. And this is unfeasible because interested parties don't even have the information required to submit relevant amicus briefs to the Commission. At the same time, provisional measures provided for under Rule 100 also fall under the ambit of confidentiality, making it difficult to ascertain either the number of such provisional measures or the level of compliance of the relevant state. And this is in contrast with the practices from the African Court, where orders for provisional measures are issued publicly. In terms of the right to a fair and public hearing, the Commission's interpretation impacts on this right, which is a right provided in various international and regional human rights frameworks, including Article 14 of the ACHPR, Article 8 of the American Convention on Human Rights, and Article 6 of the European Convention. As a general guiding principle, these treaties uniformly assert that everyone is entitled to a fair and public hearing. The public and media may be excluded from the proceedings in the interest of justice, morals, public order, national security, or the interest of minors. So the general rule of thumb is that hearings must be held publicly. Article 7 of the African Charter acknowledges the right to be heard. It remains silent on the issue of publicity of judicial proceedings. However, the Commissioner has adopted the principles and guidelines for the right to a fair trial and legal assistance in Africa. According to Article 2, Principle A3, no limitation should be placed on the categories of individuals permitted to attend hearings. The media is entitled to be present and report on judicial proceedings, and that advocate facilities should be put in place to accommodate the attendance of interested members of the public. Exceptions to this general inclusivity may only take place, again, for the interest of justice, the protection of children, witnesses, and victims of sexual violence, as well as for reasons of public order and national security. The practice at the regional bodies also follows the same general rule. Trials and proceedings must be public, with few exceptions. Article 15 of the Rules of Procedure of the Inter-American Court of Human Rights provide that hearings shall be public unless it is deemed necessary to resort to private proceedings. The same article mandates the public dissemination of various judicial documents, including judgments, orders, opinions, documents from the case file generally. Rule 21 of the Rules of Procedure of the African Court on Human Rights, on Human People's Rights, provides for the publication of the court's judgment, opinions, pleadings, statements, and minutes of public sitting and other relevant documents on its website. The African Commission diverged from these accepted standards. We see that according to Rule 90 of the Rules of Procedure of the African Commission, the Commission deliberations on communication shall occur in private, and all facets of these discussions are to remain confidential. Rule 110 stipulates that the hearings before the commission shall be held in private, and only the parties to the communication, their legal representatives, witnesses, experts, or third parties are allowed to attend the hearings, provided that they abide with confidentiality as per Article 59.3 of the African Charter. This approach represents a significant deviation from broadly accepted standards on openness and publicity of judicial proceedings. And when we look on the impact of the current interpretation of Article 59 on advocacy during protracted litigation, we see that because communications before the commission can take up to 7 years, literally several years to conclude. So in such instances, advocacy fueled by reliable data is vital in driving social change through ongoing engagement with the rights and issues before the commission, which can potentially result in legal or policy reform independent from the decision of the commission, even prior, maybe even prior than we receive the decision from the commission. The current interpretation, not the interpretation per se, but the practice of secrecy also impacts on the interpretation of the implementation of the decisions, because it seems that confidentiality extends beyond ongoing communications, as there is no database dedicated to the implementation of decisions of the commission, which makes it difficult for litigants to obtain information pertaining to implementation measures taken by member states. It would be commendable for the commission to go the extra mile and provide information on implementation as part of its resources section on the decision that it has issued on the website. There is also delays in publication of decisions that have been approved by the Assembly of Heads of States. So these aspects may potentially impact on stakeholders' ability to raise awareness, monitor implementation, and exert pressure on states to comply with received decisions, basically. In light of these implications, the litigant groups, we thought about formulating the campaign because it's imperative for CSOs to advocate for a more progressive interpretation of Article 59.3, given its impact on human rights and as well as the meaningful involvement of CSOs in ongoing litigation. So I think as a closing remark, the main objectives of the campaign are to ensure progressive interpretation of the provisions of the African Charter, aligning the practices of the African Commission with best practices regionally and internationally on access to information and the right to a fair and public trial, as well as creating an enabling environment for human rights litigation on the continent. As part of the activities that we are planning to do in the campaign, we're planning to conduct a comprehensive study, comparative study to see how other regional mechanisms and international mechanisms deal with these issues. Do they also employ confidentiality in their practices or not? So yeah, this is the introductory to the Article 59 campaign, and we are planning to launch it during the next commission session. So if any one of you is interested, CSOs, individuals are interested in the subject matter, please feel free to indicate that you would like to join us and team up in the effort here. I think I'll stop here and then I'll give the floor to Lydia. Thank you.
Thank you, May, for your introduction to the Article 59.1 campaign. I had the pleasure of working with Mai, and it's interesting that we only meet now, though we've been working very closely for so long. My intervention is very brief, and unlike Mai, I'm not going to get into the details and the intricacies of the law. but I will just ride on the goodwill and of the African Commission to introduce the implementation working group of decisions of the African Commission on Human and People's Rights. So our initiative is really based on the fact that the Commission in itself has taken significant steps to guide the engagement process and ensure effective implementation of its decisions through comprehensive provisions outlined in the new revised procedure rules of 2020. And these, of course, served to guide and facilitate state reporting, enhance state participation, and keep track of the African Commission decisions. The rules provide a robust framework for us to facilitate engagement and ensure implementation of its decisions. And the designation of rapporteur for each communication, the 180-day feedback requirement, and then mechanisms to address non-compliance could contribute key to a transparent and accountable process. And all this for us provides and creates a forum for ongoing dialogue and cooperation, and ultimately protecting and promoting human rights in Africa. We know that a decision is as good as its implementation. So the implementation working group will seek to consider part of its work a comprehensive list of what can be done. With your intervention, we have some ideas, but we welcome all your ideas into the processes of the working group. And what might be possible, of course, it's envisaged that sometimes may not be desirable and applicable in all situations and contexts. But we made a choice to develop some guidelines and also to ensure that we have an initiative. Let us start. The Commission has said, and from the discussions we've had about the resources, about their limitation in human resource capacity, but we can always be the eyes and ears and hands and legs of the Commission and support its work in implementation. So, of course, the guidelines are under the presumptions that in general, we can make a decision more visible than the African Commission in itself, and have a likelihood of it being very implemented in different areas of our countries, areas of our expertise. And of course, we know that one size fits all approach may not be applicable, depending on the political context of a country, the remedies and the recommendations that the Commission could have given, but also the resources available for its implementation. We know that some may not be immediately implemented or fully implemented, as you noticed yesterday, the discussion that came from Kenya regarding the Nubian cases. And it was very good to have that background on the issue of the Nubian cases, because we have been there trying to look at the issue of citizenship and land for the Nubian children, the Nubian community. And so being a civil society organization, maybe in Kenya, you could be best place to give us what you think might work on the ground. Who best can we work with? So this is the kind of the intervention, the implementation work group is seeking to achieve. Activities would include, of course, initially now, and a launch at the African Commission session this October. So everyone who's going to participate, maybe virtually, those who will be present, or those who know organizations that might be interested. We have identified some organizations that have been consistently present at the Commission sessions, virtually or physically, and we are reaching out to most of them. And those who have consistently made oral statements before the Commission to see how they can support the implementation working group, since we know they have constant engagement with commission. That was our initial criteria in identifying who we can work with. But that doesn't mean we might not engage those who actually have not been at the commission. They might not even have observer status. They might not have actually been at the flow of the commission or even engaged the commission before, but they have influence on the ground in their communities, with the local society, civil society, with their parliaments, and with the law in their countries, and are in best position to implement some of these decisions. So kindly let us know which organizations we can work with. We intend to have discussions during the commission sessions. We intend to also, of course, publicize these discussions. Also would like to consider to see how best we can use our resources internally to support the implementation of these decisions. If there's an expert who can do an analysis on a case, and we don't have to harness the powers of the commission to do that, but just leverage on that expertise, then we will be very glad to have that in our working group of the implementation. So this is just an overview of our group, but we would like to say we are going to also have some few strategic landmark case decisions that have been already decided and at the commission, and would like to see how to prioritize those recommendations, analyze resources that we might have, and see that as a pilot of our implementation working group, and see how we can support that decision and ensure that its replication and its impact then can have impact on the various cases and interventions that the commission might then have after that. We will have something like a best practice to share with the commission and say, this is what is maybe working, or this is not what is not working. But we intend to work closely as well with the commission to ensure that the working group, of course, is guided by that, but also to look, because on the ground, and as a sense of urgency of victims, what is an assessment and likelihood of the political context of each recommendation. Maybe it's a little bit political, for example, and there needs to be a bit of confidentiality maybe on a case, and how we can then intervene on the same. So for now, we would like to establish and engage with you. We are going to create a coalition. It's already there, but we're just going to invite all of you to join it, to have, for whoever has an interest in the issues raised on decisions and judgments of the commission, to maintain links on the ground and have an understanding of how best we can maintain our communication on the ground, but also have a center point as a working group to engage the commission. And then also our key element will be also in intervention or in our different steps, to see if there's a mechanism that the government has introduced to follow up that. And if there's none, how best as a working group can we ensure that that happens? And this, of course, can come in various ways. I could discuss different ways on that, but strategically, of course, to look at maybe our judicial systems in implementing international decisions locally, how they translate into that, but also maybe our parliaments and how they might maybe pass a law in case of discussion on legal reform. In conclusion, I'm inviting you all, please, to kindly join our working group, and please feel free to reach out to us on email, on WhatsApp, on any form of that we will have, but we will definitely be at the next African Commission session in Arusha. Kindly inform organizations that might have decisions with the commission and are interested in seeing how this might work. You might not actually be in the African Commission, in the African region, but mechanisms from different areas could have worked, and we welcome all ideas to ensure implementation of the decisions of the African Commission. I thank you so much.
Thank you so much, Lydia. Just to add, we as litigants, we've sent a request of a dedicated email address to allow litigants who have submitted communications before the Commission to follow up on pending cases, not in terms of substantive aspects, it's just in terms of procedural status. We have received an acknowledgement of receipt of our request from the Commission. But definitely, Madam Abiola, we're looking forward to receiving a favorable feedback soon. So I just wanted to put that there. Thank you so much.
Thank you very much, May and Lydia, for that advocacy interlude. I see there are a few hands, Chairman and Abiola, please, you may respond.
I think you should go first, Dr. Chairman.
Thank you so much. Thank you so much to the presenters, Madam Mia and Madam Lydia, for your presentations. If I understood correctly, the campaign around Article 59 seeks to be able to get, more information on communications. And the campaign is hinged on the provision of Article 9 of the same charter. I think that there might be some contradiction here because the Commission is required to actually implement not just the substantive provisions of the charter, but also the provisions of Article 59. And if you read properly the provisions of Article 59, you will see that the Commission has mandatory obligations. Sub-articles 1, 2, and 3 contain the word shall. So in all those proceedings, the Commission is required to exert confidentiality. Now, why am I taking the floor? I'm taking the floor because as civil society, we are partners in the Human Rights Project on the continent. And that means that we also need to ensure that campaigns do not run contrary to the provisions of the African Charter. And also our relationship with litigants should not go contrary to the provisions of the African Charter because the requirement of confidentiality requires that states are given some opportunity to constructively engage to ensure that African solutions are preferred to intractable human rights problems. Now, when we require or seek to get more information on communication processes that are still in progress, the danger is that you might actually, the word is not spoil, but the danger is that you might actually jeopardize the constructive nature of state engagement. And that is why that provision of Article 59 is there. So if you're saying that we should have more information on communications that are, or correspondences between the parties that are required to be confidential, is your campaign looking at the potential consequences of not actually getting the desired results of what you seek to achieve? Have you thought about that aspect? And the other question is, do you also appreciate the potential for conflict between seeking more information on communications and looking at the requirement of confidentiality within the context of the African Charter? And then the third and last point I wanted to perhaps note is that when undertaking comparative analysis on access to information principles, you cannot use the same paintbrush that you use for either the inter-American system or the European system for the African human rights system, because the African human rights system has a lot of idiosyncrasies. It's been designed in a particular way to achieve particular results, as at the time it was designed in the 70s. So you have to pay attention to that, such that if you find out that the openness or the level of access to information in the inter-American system or at the UN level or at the European level are more effective, it doesn't mean that there is no access to information at the level of the African Commission or in the African human rights system. But you just also have to pay attention to the goals that the provision of Article 59 seeks to achieve by seeking that correspondences between litigants and state parties are maintained in a confidential manner. Thank you so much.
Yeah. Okay. Thank you so much, Dr. Chairman. I think you set the scene for the intervention that I'm about to make. So I will just continue from where you stopped. But let me start first by thanking my sisters for their presentations and the very brilliant initiatives. Because as we might all be aware, much of what the African Commission has recorded up to today in terms of success has been as a result of the efforts of civil society and their partnerships with the Commission over the years. If we track back the history of the Commission, going as far back as before it was even established and after it was established. And the ability of the Commission to unpack its otherwise vague and open-ended mandates and to clarify working methods, which are now yielding some of these results, which we see as a half full glass, have also largely been as a result of this partnership. So we really welcome and continue to embrace these kinds of initiatives. Having said that, let me continue from where Dr. Chairman stopped, just to kindly reiterate that the Commission works within a legal framework. And this legal framework is set out by the African Charter on Human and People's Rights. And as much as the Commission can be progressive and creative in its interpretation of the Charter, and which has been the case largely over the years, it cannot operate outside of the purview of the Charter. Now, in relation to Article 59, we're mindful of the implications for access to information for stakeholders. And just to give you a little bit of a history about the journey regarding Article 59, as far back as 2006, when I first had an encounter with the African Commission as a seconded expert, the scope of Article 59 as interpreted politically was even wider. It was applied to all the outputs of the Commission, such that even resolutions could not be published without checking with states. And the Commission was being requested to remove resolutions referenced in its activity reports until states were given the opportunity to respond. I will not mention specific states, but for those who've been around the system for a long time, I'm sure you would know which states we're talking about. And the Commission then took the initiative to push and clarify the legal regime imposed on it by Article 59 to say this is limited explicitly to communications. And we might understand why, because that is at the time that the Charter was adopted, as we all know from Tavox Repertoire and all of that, what the champions of human rights really wanted was a court, but this was not achievable. So even having the communications procedure incorporated needed to come with some concessions. So as Dr. Chairman indicated, the communications procedure was envisaged to be confidential until the activity reports in which they are referenced have been authorized for publication. Having moved away from a regime where even resolutions were being requested to be not to be published, and the Commission was able to clarify that, and that position was taken. Now, in relation to communications, we also now then had to deal with a regime where the Commission was being asked to remove communications that were already referenced in its activity reports from its activity report. So the Commission also had to deal with this. This was the regime that I met in 2012 when I became a regular AU staff. And I recall the engagement by the then chairpersons of the Commission, and ultimately the practice that we now have is that member states provide any comments that they have on the activity reports of the Commission, and they are now annexed to the activity reports of the Commission. The Commission has defended the integrity of its reports, and today it publishes its reports as presented, and any comments thereon are then annexed. A couple of days are given for states to provide in writing whatever content, comments they might have made during the course of the presentation, and then these are published together with the article, with the activity report of the commission. So this has been the journey for Article 59. So what does this mean in practice? What does the commission do? What it then means is that only decisions that are finalized are made public. But the commission does not treat confidentiality as between, it's confidentiality only to the public, but not as between the parties. So the parties remain seized of every decision and every step taken by the commission along the lines. Now, at some point, the commission experimented with, because when the commission submits its activity reports, in the past, it would list communications that were seized, communications declared admissible, those declared inadmissible, and those finalized on the merits. And as we all know, the final ones are the non-seizures, the inadmissibilities, and the merits. So admissibility admissibility decisions were decisions referenced in activity reports, but they related to continuing communications. Seizures were decisions taken, but they related to continuing communications. And at some point, the commission experimented with publishing seizures and admissibility decisions because it thought that, it considered rather that because they were referenced in its activity report, it might be okay because it was already there. And if the activity reports were authorized for publication, those communications are already referenced. But what then happened was that we had complainants who would then go to the press as soon as they got seizure decisions, or as soon as they got admissibility decisions, even before sometimes, because for member states, it takes a while, even, for the channels of communication and things like that. So it became problematic. And then the commission had to reflect on that. And what became clear was that to comply with Article 59.1, the commission could only actually publish communications that have been finalized. So this is the current regime. Now, in terms of information about cases that are pending before the commission, this is also a legitimate issue that has been brought to the attention of the commission by the litigants group. And a couple of letters were written in the past. I have to say that the engagement has since dwindled, and I think it has to be revived. And this was brought to the attention of the commission. Again, these had to be weighed vis-a-vis not only Article 59.1, but also the practicalities of developing or publishing cause lists, because this was one of the requests that was made. We've had situations where parties are requested to know the status of their communications. You would tell them that it will be considered at the session, and then they would show up. And if those cases were not considered or they were not given audience, then they would say, but we are here. But the commission doesn't necessarily engage with parties unless there's an oral hearing. And also it could schedule a communication for consideration. But if the exigencies of the priorities at that particular session require that such communications should be deferred, in terms of the consideration, then the commission would have to prioritize. It drafts its agenda, but when the commission is sitting, is actually when, as a collegiate, they decide on the priorities for that particular session. So again, this made it impossible for the commission to publish cause lists. And what has been considered to be possible, and which we're interrogating at the level of the Secretariat currently in the list, is the possibility that we have under the current Rule 32.3 of the 2020 rules, which permits the chairperson of the commission to communicate to the public general information on deliberations in private sessions, subject to the exigencies of Article 59. And what we are considering in that regard is in the list, a table of communications pending before the commission. And my colleague, Zelalem, has been working not only just on updating the table, but also in creating, I don't know what the terminology is, to have, clusters, descriptions of how many, the matrix, yes, and also countries against which, cases are pending, the regions, distribution according to regions and things like that. So he's working on all of those things together with Mr. Pedro Rosako, who currently oversees case management. So we're working on that at technical level because we have the instruction at the level of policymakers. So I would just like to say that. Then vis-a-vis amicus curiae, and that's another issue. Previously under the 2010 rules, there was only one sentence about amicus curiae interventions. And as a result of that, we received all forms of interventions. We received interventions that came together with the seizure applications. Of course, that was no amicus curiae, because there was no way you would have known that the case was pending if you were not a friend of the complainant. We also received submissions that we could not necessarily classify as amicus curiae in terms of the contents. And so it became necessary for the commission to elaborate on the regime governing amicus curiae interventions. When the 2020 rules were being revised, provisions were introduced to extend the scope. And there are three possibilities now under the 2020 rules. The commission could make a general call for interventions. It could make specific calls for interventions, and applicants may approach third parties, uninterested third parties may approach the commission to request for the opportunity to make an intervention. So these are three possibilities. So it's a bit clearer. However, as you rightly noted, my sister, the issue of access to information about cases pending is still a constraint. It obstructs the effective use of this possibility. And so at the level of the commission, again, we're exploring the opportunity presented by Rule 140, and we currently have a draft of practice directions on amicus curiae before the African Commission. There's a draft at technical level. And one of our key findings so far is that because of the current interpretation and legal regime, the practical implementation of Article 59.1 by the Commission, the most likely means of the Commission receiving amicus curiae interventions will be through general and specific invitations, because the public can only become aware of cases before the Commission after those cases have been finalized, either by being declared inadmissible or after taking a decision on the merits. And you can only intervene if maybe there's a request for review of admissibility or review of the merits decision. That's what that means. It becomes more complicated because the 2020 rules, again, based on advocacy from civil society and a lot of engagement with stakeholders, now makes seizure an administrative procedure. So there are even no seizure decisions. There are, it's now an administrative finding, following which substantive submissions are then made by parties. So the only real decision that are taken, the first time that the Commission truly takes a decision now on cases, is at the admissibility stage, because seizures are now administrative. So even, you cannot get decisions on seizure now on the websites of the Commission. So in that regard, what we are looking at, and again, of course, in line with the best practices of the Commission before issuing the practice direction, just in the manner that the Commission develops soft law instruments, we would engage with relevant stakeholders. We would publish it on our website for calls and for comments. The Commission has established practices in any event, so I will not mention all of this in details, but there are established practices and we stand guided by our policymakers. So that's what I would like to say about amicus curiae. Now, one other thing that we're looking at, or should I say two other things, is the possibility of also using amicus curiae interventions for implementation, to monitor implementation, as well as in relation to reparations hearings, which are now possible also under the 2020 rules. So these are some of the considerations that we're having. Lastly, my dear sisters, I would just like to say that it would be great if initiatives also emerging from civil society, should I say, brought to the attention of the Commission, or if engagements with the Commission start early, at the early stages of this initiative, so that they can be further enriched and also grounded in the practical realities of the context in which the Commission is working, so that these initiatives can actually truly speak to the situation of things, and also ultimately meet the objectives, the mutual objectives of the Commission and the stakeholders, which is basically improving access to justice within the context of the communications procedure of the Commission. We have a working group on communications. My colleague who oversees case management is effectively the secretary to the working group. And there are opportunities presented by the virtual meetings that we have these days now, perhaps even to engage virtually by briefing, and just to carry the working group along and to see how such initiatives can improve our working methods. We are open to working with everyone, NGOs, NHRI, stakeholder, state parties, everyone is a stakeholder in the African human rights system. I want to thank you again for these initiatives, and we've taken note of what you've said. We'll find out about the requests because these shoes, I've just stepped into them, so I have to find out if there are some things I've missed, and then we'll take it up from there. Thank you so much.
Yes, thank you very much, May and Lydia, and to Dr. Chairman and Madam Abiola. I know that May, you would like to respond, but we're running out of time, and I think it's an ongoing conversation that we will have with the commission going forward. I say we because I'm closely associated with both campaigns, and I think at the core, it's an issue of disagreement about interpretation of 59.3 and what measures taken mean or should mean in the context of what the litigants considers to be measures, and we would not include pleadings to be measures taken by the commission, for instance, but the commission thinks those are measures taken and therefore are confidential. So it's a bit of a disagreement with the interpretation of the commission, but I think it's a conversation that we will have more, follow up with the commission and have a conversation about whether there is a reasonable middle ground that the commission can come to so that it also aids the ability of litigants to access the protective mandate of the commission. But colleagues, a round of applause for our panelists and for the response from the commission. I think that brings my job to the end this afternoon, and I will hand over to Felicia now to provide some concluding remarks to the conference, ending lunch and our case discussions in the afternoon. But thank you very much for your cooperation this morning, and I hope that we will have an awesome lunch and we'll return for the case discussions in the afternoon. Thank you.
Thank you very much, Michael. And so let me just start by appreciating every one of us in the last 3 days. I mean, of course, we are still going to have another session this afternoon, but technically, in a sense, I think we are drawing to an end the conference itself as it relates to implementation of decisions of the African Commission on Human and People's Rights. And in this regard, I would like to thank all of our presenters, the chair of each panel, our moderators, and I would want to really thank the delegate of the African Commission for their robust engagement in the last 3 days. And it's quite exciting to see that even on the final day when fatigue would naturally have been setting in, there have been a lot of engagement in today's presentation. So I would just want to wrap up by drawing us to a close on certain maybe immediate outcome that would be expected from this conference by the end of today. I would start with our presenters. I think in my opening remarks, I did mention some of the expectation of this conference. So for us now, the job is really for us to, internalize some of the discussions that we've had in the last 3 days, internalize the feedback and the comments that we've gotten from the delegates of the African Commission, and improve and complete our paper, put it in a final fourth draft, which I expect will be much more robust now in integrating some of the things that we have listened to in the last 3 days. So as a researcher on implementation, one of the words that we play around with is that we use the word SMART. So we say clarity, recommendation must be specific, it must be measurable, it must be achievable, it must be relevant, and it must be time-bound. So I think it's quite specific what I want from you. The final draft, first draft of your paper, in terms of being measurable, the draft should be around 8,000 to 10,000 words for purposes of publication. So it's relevant, of course, because it's something that you've submitted for this conference. So there's I don't think that's contentious. And now it has to be time bound. So we will expect that draft by the 31st of October from our presenters. That's our time. And I think it's achievable because it's 6 weeks from now. I think we already have the first draft, and now it's really about improving and finalizing the paper. So that would be for our participant. And I would just want to quickly have to see if there is any clarification, any comment from with respect to that information from the presenters. Yes, Dr. Okolese.
Thank you so much, Folu. So with respect to the publications, I suppose it's going to be peer reviewed, right?
Definitely, it's going to be a peer reviewed publication, and that's why we want it by the 31st of October to allow us to,
so
commence that process.
In that case, could you just give us a rundown as to the entire process? When do we expect publication by? And is it going to be in a special issue of the African Human Rights Law Journal, or are we going to publish it under the African Human Rights Yearbook?
So we at the moment, depending on how we are still trying to finalize the channel of publication. One of the proposals, of course, is having it as a special issue of the African Human Rights Law Journal. We are also looking at the possibility of having it as an edited book with the Pretoria University Law Press. But we will definitely finalize that because we've stopped discussion around that in the last couple of weeks to focus on the logistics of this conference. We will communicate that very soon. But in terms of when to expect the publication, I think we would say in the first quarter of 2024, because, with December, it's a bit tricky. So for our reviewers to have a bit of time to give feedback, and then I don't think there would be realistically enough time for people to probably, incorporate some of the feedback in December. So we're looking at the first quarter of 2024 for publication purposes as early as we can. Okay, thank you very much. Now I would move to my second delegate that have been giving us useful. It's not every time that you see the respondent in an interesting position, and I think Dr. Pedro did say that 3 days ago that he was a happy respondent. And thank you very much. So as we know there's been the Zanzibar conference, there's been the Dakar conference, and I would want to maybe try something a little bit differently for purposes of what I would call now the Pretoria conference, which would become the third one that we're adding to the implementation seminars and conferences on the African Commission. So there are a couple of, there have been a lot of recommendations, suggestions, and while I know that some of these recommendations are quite elaborate, and the Commission would definitely need to maybe go back to the drawing board to reflect on some of these recommendations. I've made some reflection over the course of the 3 days looking at some of the recommendations, and I have a bit of recommendations here that I would want to apply the SMART test to. But what I would then add, because you see, we talk about coordination issues when we look at implementation, and we've also spoken about the fact that recommendations should be broken down at the national level. For example, we decide, is this for the executive? Is this for the legislature? So I see the delegate in front of me, and that's what I intend to do with each recommendation that I would be speaking about. I would want to be very precise about who we would expect to work on this particular issue, so that when we have to send emails and follow up, we are dealing directly with that person. So the first one is we're starting with some of the things that are already in the rules of procedure of the African Commission. The first recommendation here is that there should be a systematized way of sending decided communications to national human rights institutions. Dr. Pedro, what do you think about this recommendation?
Yes, come again. I was reading something here.
Okay, I think now you all need to pay close attention because this is really for you now. So systematize sending decided communications to national human rights institutions in accordance with Rule 1252 of the Rules of Procedure of the African Commission. Yes, so the Rules of Procedure says that the Commission should send decided communications to national human rights institutions. It's in the Commission's Rules of Procedure. So we're saying we want it to be systematized so that we know that at every point in time when there are decided communications, the national human rights institutions know that they will have a formal channel through which they get these decided communications as opposed to ad hoc approach.
Yes, thank you. I'm sorry for taking you back. Yeah, that is true. As it has been mentioned during the first day and even yesterday, we did not have at the level of the Commission formal and formal proceeding in the matter of the follow-up of the implementations. So that process is going on. We are working on it. There is a very important reflection at the level of the Commission when it comes to the communications, starting from the processing of the communications, the decision on the communications, and the follow-up on implementation. So naturally, when you are going to implement that reform on the matter of the implementation of decisions, we are going to systematize the process of sending or sharing the decision of the Commission with all stakeholders, including especially the national human rights institutions.
So sorry, Mr. Pedro, because we're just running a bit out of time. Sorry for the interjection.
Yeah.
I think you agree with that
Yes.
recommendation. Yes. So what I just want to get from you now is, because it has to be time bound. Usually you would give 180 days, for example, to the respondent state to provide information. When do you think we can realistically expect this to be systematized from the side of the Commission?
Yes, the SEC is going to.
Thank you very much. As much as we would like to make commitments, we also don't want to be ambushed. But we have to be mindful also of the rules. Yes, we need to provide information to NHRIs, but don't also forget that states can contest decisions on the merits. The rules allow them the same 180 days timeline to contest the decision. So we have to be mindful. So we will transmit. We need to elaborate the regime for engagement of NHRIs on follow-up. We have to take a closer look. So the rules are there, but the practical implementation require some reflections. So a lot of ideas have been put on the table. I listened very carefully to Deborah yesterday, and I believe my colleagues also did. But we have to then look at that obligation to pass on information to NHRIs for purposes of follow-up on implementation, vis-a-vis Article 59.1 and vis-a-vis Rule 122, which also allows states to request a review of decisions. So the commitment that we can make at technical level, subject to the directions of our elected officials, is that we will take this recommendation on board and run with it within the rules. Thank you.
Okay, so there's no time for that. What about the second one would be to, it's still within the rule 125.7, presentation of compliance and implementation report in ordinary session of the Commission. Is it another ambush to ask for specific time for that? Because maybe just to clarify, we are not exactly also starting something different or something new. There are previous decided communications already. And I think in terms of systematizing, what we just mean is that within the Commission itself, we know that this, it doesn't have to be maybe some of the decisions that you think are still within the confidentiality provision, I think that's okay, but it's just to have it systematized. Okay, Madam STC.
Thank you. Maybe to help us, okay. Maybe to help us first gain time to take away the key recommendations, some of which you have noted on our side, and also 3, to contextualize things properly and carry this partnership forward. My recommendations will be the following: that you read out the key outcomes, the key recommendations to the Commission. We have committed to, and what we started on our part as we presented, is the clarification of the framework for follow-up on implementations. We did indicate that we're seeking to clarify that. We have people who have been onboarded. Madam Eunice is dedicated to that. This is a process that she has started working on. So if we have those outcomes, we will commit to incorporating them in our process. We will commit to coming back to you and our other stakeholders by whatever other means we would be engaging with a practice direction or a clarified framework on implementation, which will be transparent and made known to all. So this is what we also intend to systematize. So it's not these are components that we're talking about. We're looking at a holistic systematization of the follow-up or monitoring mechanism within the African Commission. And we started a process already internally, and we will take also from this engagement that we have had, we will also engage with states as critical stakeholders as well. We will engage with the different stakeholders and come up with a roadmap or a framework that will be communicated to all, which will be transparent. This is what we intend to do. Thank you.
Okay, thank you, Madam STC. Maybe what we can then do is, like you said, I'll read out some of these recommendations, because like I said again, we cannot be victim of the same thing that we complain that states do at the national level. And I think that's also one of the reasons why we've had a couple of colleagues from the Commission. So what I will do is I will read this recommendation if you agree with them, and then you just tell me who I should follow up with. For example, if in 6 months' time I want to say, please, can you please tell us what is going on with this? So the first one in terms of systematizing, sending decided communications to stakeholders, who is the person that I should reach out to? You agree to that. So who should I follow up with? Madam Eunice. This is for everyone in the room as well. So Madam Eunice and the STC. And with regards to presenting implementation report in the ordinary session of the Commission, who should we follow up? Mr. Pedro. Okay. So I'm pretty sure this is probably for Mr. Zilalem, but I'll let the head of the Secretariat decide. So setting up a database on status of implementation, keeping it up to date. Mr. Zilalem, thank you very much. So there's been a suggestion, I think this I need to confirm if you're happy with this, that for sharing of best practices, so that we don't just talk about the bad all the time, and we can also see the positive. So the suggestion is that an agenda on the public session of the Commission is included for states to share best practices with regards to implementation of decision. Let me know if you're happy with that, and then who to follow up with.
I think we told you that it's in our 2024 work plan.
But who do we follow up with?
Office of the STC.
Okay. And systematization of holding of implementation hearings. I think that was not contestable as well. Who do we follow up with?
It's something to be considered within the framework of having a framework. Madam Eunice and the OSTC, yes.
Okay.
But it's not something that will happen in silo. It has to be within the framework.
Okay. And follow-up missions on implementation of concluding observation. I think it's closely related to implementation hearing. Are you happy with that?
Yes, it is agreed. And again, as I said, it's going to be within the framework. So we will be reporting on an entire framework when you follow up. Because don't forget that missions have cost implications. So,
definitely, yeah. I understand. And the final one, because I think now we need to break for lunch, is the need for a comprehensive study, maybe within a very short time frame, just to give a starting baseline to, because we've been here saying things about low level of compliance and all of that, but from the commission itself, is a comprehensive study showing the status of implementation of certain of decisions of the African Commission to allow scholars, for example, to have much more reliable information to refer to in conducting studies like this.
Again, the OSTC can give an update, but we're not committing to a timeline for the study. As I indicated, it requires resources, both human and material. And so we have to bear this in mind. So what will be the commitment of the center in supporting this? Thank you.
Well, the commitment of the center in supporting this study, you can count on us definitely. But I think it's also about the fact that we have done a couple of studies on implementation of decisions. We've done in conjunction with various stakeholders, but I think there's a difference, and it's more legitimate when it's coming from the body itself that issued a decision, like what the African Court has, for example. I think that's the kind of study that we're talking about, and definitely we are definitely happy to collaborate. The commitment of the center is not in doubt. Anytime you need us, you can let us know.
If I may, I don't want to reduce this to a bilateral, but let's speak concretely, because there are lots of conversations, and oftentimes we find out that the realities are a bit different. A lot has come out of this conversation. As I indicated, a lot came out of Zanzibar and Dakar. We found some elements in our new rules and some of the structures we're trying to put together. I believe that, for instance, the center has an implementation unit with I don't know how many experts. The commission has only one focal point for implementation, who has graciously been loaned to us by the Republic of Botswana. So we have to look at these realities. So even as we ask for commitment, we have to ask ourselves, what can come out of this? How do we concretely take this forward? I think this is a conversation that can take place at bilateral levels between the two institutions, but also take a comprehensive and inclusive approach to developing whatever framework we will be developing as well. So we are open to collaborations to make this happen, so that we just don't talk, we actually have a system that clearly reflects all these positive, all these best practices that we've talked about here, and which also gets the buy-in of the various stakeholders. So we are open to this commitment, and we would like, beyond these commitments that we're making, for there to be that understanding that we need support, and that we are open to taking this forward concretely. I will just leave it there. Thank you very much.
Thank you very much, Madam STC, and thank you to colleagues from the African Commission. At this point, I would not hold us further. Please, we are going to break for lunch now, and I think we'll have our lunch outside like we had it yesterday. Thank you. Can we please come back by 1:30? Thank you.
the speakers.